The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court. First case is 20-1079, Daniel Patrick versus Robert Wilkinson.
Thank you, Madam Clerk. Mr. Wooster.
Good afternoon, Your Honors, and may it please the court. My name is Daniel Wooster.
You represent Mr. Patrick, the plaintiff?
Correct, Your Honor.
Go right ahead.
Thank you very much. My name is Daniel Wooster. As Judge King just mentioned, I'm appearing on behalf of plaintiff appellant Daniel Patrick in this case, who owned a bump stock that is currently in the possession of the ATF and who challenges the bump stock ban that was signed by Matthew Whitaker. The district court erred in granting the government's motion to dismiss for lack of standing because my client prospectively challenges the rule, so there is a live controversy. No one questions that my client had standing to challenge the bump stock rule at the outset of this litigation, which is the relevant inquiry. And the operative complaint continues to challenge the bump stock rule as signed by Matthew Whitaker and alleges that he was invalidly serving as acting attorney general when he signed it. Even just reading the complaint in the light most favorable to my client, he continues to prospectively challenge the rule despite Mr. Barr's attempt to ratify it. For example, he seeks a declaration that the final rule unconstitutionally and unlawfully caused my client harm from its inception because it deprived him of his property right to alienate his bump stock from the day it was signed, and he was not constitutionally or statutorily authorized to issue the final rule. That's at J19. In a separate declaratory relief claim, my client seeks that issuance of the final rule by Mr. Whitaker, wholly apart from Mr. Barr's ratification on March 14, 2019, was illegal because my client was injured from the final rule's inception and Mr. Whitaker was not constitutionally or statutorily authorized to issue the final rule on December 18, 2018. At JA 19 and 20, you can see that we also sought relief in the alternative for the harm caused between the time Mr. Whitaker signed the rule and Mr. Barr ratified it, but that is a separate request for the declaratory relief. This was first made clear in our reply to the government's opposition to our summary judgment motion. To give some brief context, the parties engaged in cross motions briefing. The government filed a motion to dismiss.
Counsel, not to stop you, but I'm glad you started here, and I hate to jump in so early, but I'm not sure I read the complaint the same way you do, and so I want a little help understanding that. When I look at particularly paragraph 23 on JA 18, and I look at that in light of the remainder of the complaint, including the request on J19, subparagraph E, about curing the harm, and in light of the amendments that you're making, with the red line copy of this complaint that's submitted, it doesn't look to me at all like you're challenging the ratification. And in fact, it seems that you're accepting that the ratification cured the problem. Have you given me everything that I can look at to think about that differently? Or is there anything else that you think I need to look at?
Because of the standard of review, Your Honor, which is to read the complaint in the light most favorable to us, and the fact that, as Your Honor just mentioned, it, quote, seemed to no longer prospectively challenge the rule, I do think it's important that at the hearing, we made abundantly clear to the district court judge that we were continuing to prospectively challenge the rule and that we were challenging Mr. Barr's ratification.
So how is that consistent with the actions you took with the joint status report after the ratification was filed, where you withdrew the preliminary injunction motion? I mean, that seems to confirm my reading, which is you don't have a future injury any longer. That's what the joint status report seems to suggest. How
Your
am I
Honor,
supposed to read it that way?
we don't actually agree that you should read the withdrawal of the preliminary injunction request for this reason. We filed the motion for preliminary injunction in the pre-enforcement stage while my client still had his property and before it was turned over to the ATF in an agreement with the ATF. So once the rule actually went into effect, and it was no longer necessary to continue to bring a preliminary injunction motion on an emergency basis, which is how we initially brought it, seeking to enjoin the rule from going into effect. At that point, my client had already turned over his bump stock to the ATF, and then we were claiming that and then we made our challenges going forward. It was no longer necessary to do it in an emergency posture.
Do you remember the date when the rule went into effect?
If I recall, it was March 23rd, Your Honor. I can't remember off the top of my head. I apologize.
1919? I mean, 2019? Yeah, 1919.
Yes, 2019.
That's how old I am.
Only you
No.
Judge King.
I didn't know that they had bump stocks in 1919, Your Honor.
Right, but in 2019, Whitaker took over in late 2018, right?
That is correct. That's correct, Your Honor.
And they allege he didn't do much of anything until he signed this bump stock thing because everybody at the Justice Department knew he was illegally appointed.
That's correct, Your Honor, and yet he still signed this regulation, which is what gave us standing to bring the case.
And Mr.
It
Whitaker,
was ratified by Mr. Barr when he came in. You agree with that, don't you?
Not quite, Your Honor. It actually wasn't ratified as soon as he came in. It was actually ratified by Mr. Barr in the midst of highly expedited briefing that was occurring before the DC Circuit at the time, after we filed our opening brief, and just before the government filed its expedited response. And if you look at
do you agree that it was before the rule went into effect, right?
That is correct, Your Honor.
In fact, I think it's the 26th of March. He ratified it on the 14th of March. So before it went into effect, he had already ratified it.
We agree, Your Honor. He ratified before the rule's effective date.
all right. So Mr. Woofter, then if we disagree with you regarding the Attorney General's action and its validity, do you lose? In other words, if we hold that Attorney General Barr acted in valid manner in ratifying the rule, is that the end of your case here?
I think it depends on what you mean by, I have two separate answers to your question. In short, the answer is no, but the longer answer is, it depends on what you mean by validly ratified the rule. There are two different...
We hold that Attorney General Barr was authorized to ratify the rule and did so. Does that end your case?
We still...
Why not?
We still have a separate challenge based on the president's policy of designating invalid acting officers.
Why does that matter if Attorney General Barr had the authority and acted within that authority in ratifying the bump stock rule?
If your honors hold that the ratification was valid as both a matter of the voluntary cessation doctrine and as a matter of not implicating section 3348 of the FERA, which has an anti-ratification provision, we still have our general policy claim against the government for its policy of designating invalid acting officers, such as Mr. Whitaker. And I should note here that although the government argues that there are these 7 consecutive steps that would have to occur before my client would be harmed again, if you ask my friend on the other side, I believe he'll agree that the first 6 of those steps already have occurred with the designation of Monty Wilkinson as the acting attorney general, when there was a validly serving acting attorney general at the time, Assistant Attorney General John Demers, Assistant Attorney General of National Security. So, in our view, that just goes to show that this is the kind of injury that under both as a matter of a voluntary cessation and as a matter of our policy argument, the government not only says it has the authority to continue doing this, it has already done this for the very office of the Attorney General itself.
Counsel, so you brought up what you're referring to, I think, is your policy argument, the policy of replacing. Under A3, do you agree that that is an action that can be taken by the president, and I think it says parenthetically only the president?
This is 3.3.4.5.
The appointment under, correct, A3, that this is all about, or at least one of the arguments is about, that can be done by the president alone.
3345A3 does vest under the general vacancies law in the president alone the ability to designate certain individuals as an acting officer.
And that is the conduct, or that's the authority under which the policy that you're challenging is exercised. That's how it was done here. The president signed something under A3 to say that Mr. Whitaker was the attorney general. What I'm trying to get at here is you want us to enjoin that quote unquote policy, but the person who does that action is the president, and the president is not a defendant. I understand how we could enjoin the president from using A3 in the manner that you think is improper when the president is not before us.
Your Honor, we do sue the United States as well. And there are cases, I believe we cited these in our brief, from both the Supreme Court and the DC Circuit suggesting that this isn't injunctive relief against the president himself that we're seeking. We are seeking a declaratory judgment against the United States that A3 cannot be used when one of the exceptions in 3347 is in effect.
I just want to make sure I understand your argument, because the point of that is the only person who can exercise that official duty is the president of the United States, right? President Biden
Correct.
Is the only person that can do that. And so a general injunction isn't what you're seeking. You're actually seeking to enjoin the president, because it's an official duty of the president. And only the president. I mean, the statute couldn't be clearer. The president's not before us, President Biden. And second, even if he was before us, we don't have authority to enjoin him from the exercise of his official duties. And so if we get to this policy argument, I'm having a really difficult time seeing how you've sued the right parties, and I understand why you didn't sue the president, because I suspect you recognize that you can't get an injunction against the president for the exercise of his official duties. So how do I get through that thicket to even consider the merits of your policy claim?
Your Honor, respectfully, we are seeking a declaratory judgment that would affect the president's ability to exercise his A3 authority, but that would be no different than what the Supreme Court did in the line item veto case, where the authority to line item veto appropriations bills from Congress was given to the president and the president alone. And the court still saw fit to say that it was all right to enjoin the ability to do so. Or I believe in that case, it was actually grant a declaratory judgment that violated the Constitution.
All right, but how in this context, so your position is we can declare that the president may not exercise that authority?
Yes, we think that.
Is that what you want us to declare, or do you want us to declare that what Mr. Whitaker does is illegal?
With regard to the policy argument, to be fair, we do seek a declaration that the A3 cannot be used in this way, enjoining that policy. But the court, as you highlight, Judge King, needn't go anywhere near that far, because we have a live challenge to this current bump stock rule. And to get all the relief that we seek, this court need only say that Mr. Whitaker was invalidly designated under 3345 because there was already a valid acting attorney general that was designated under 3347A1B. And
you talk about Mr. Rosenstein there, is that right?
That is correct, Your Honor. Rod Rosenstein automatically became the acting attorney general at the time that Mr. Sessions resigned.
But then what happened here was then Mr. Whitaker replaced Mr. Rosenstein and not Mr. Sessions.
That's correct. So what the president did was he displaced the statutory designee for the acting attorney general, a statutory designee that has been around in a statute that long predates the current iteration of the Federal Vacancies Reform Act, with an employee.
We've got a case, so before you run out of time, we've got a case here in the Fourth Circuit, the Smith case. There's a lot of Smith cases, but this one is another Smith case where Judge Wilkinson wrote an opinion with Judge Traxler and another judge, Judge Floyd, and they said that what happened with Whitaker was all okay.
If I may, I'm out of time, Your Honor, but just to briefly answer your question.
Yeah, I want to ask. I want you to. What they say it's okay. How are you going to overcome that? We're bound by prior decisions of panels of this court. This panel is.
Of course. Just very briefly, with respect to the merits constitutional analysis, we believe that should be treated by this court as dicta, especially in light of the avoidance canon, because the constitutional analysis in Smith made not a whit of difference to the outcome of that case, given that the court expressly found that even if Mr. Smith were correct on his appointments clause claim, he, quotes, would still not be entitled to the relief he seeks. But whatever this court...
We would have to face up to the Smith case and say it's not entitled to be considered as precedent and declare what they did as dicta, correct?
Correct, but it needn't even do that.
I thought you would say that we would have to go in bank and fix it because the Smith case is wrong. We haven't done much of declaring prior decisions about fellow judges as dicta.
And just very briefly to follow up, there is no question at the very least that the footnote that had the court's musings on what the FVRA says is dicta, because as the court itself acknowledges there, Mr. Smith conceded that if the VRA applied, its statutory text authorized the designation of General Whitaker. And in addition to that, the court itself said that the party had just suggested that the FVRA might not have been available there. So at the very least, there's no question that this court is not bound by what the court said in Smith with regard to the Federal Vacancies Reform Act. And with that, I'll reserve the remainder of my time.
Very good. Mr. Hinchelwood, I mispronounced.
Oh, you got it right. You got it right. Thank you, Your Honor. Brad Hinchelwood for the United States. I think it's important. Thank you. I think it's important just to start out by teasing apart the two different claims here. So I think the simplest one to address quickly is plaintiff's claim about this purported policy of noncompliance with the FVRA. The simplest resolution to that claim is precisely what the district court did here, which is to recognize that plaintiff has to demonstrate an imminent or certainly impending injury from that alleged policy in order to demonstrate any entitlement to relief and any standing to seek any relief on that claim. And plaintiff hasn't even tried to meet that standard here. He doesn't acknowledge it in his brief and really has made no effort to show that he meets it. So I think that's, as to that claim, that's the simplest path here. Now, as to the other question here, plaintiff has in this appeal tried to contend that he is bringing a prospective challenge to the rule that's forward-looking. And not only is that inconsistent with the text of the complaint for the reasons that were being discussed earlier, and with the conduct immediately after the ratification by Attorney General Barr, it's also just not consistent with the way plaintiff briefed this case in district court. So the government moved to dismiss this case, and it emphasized that Attorney General Barr had validly ratified the rule. If plaintiff was actually contending that the rule is not valid,
I thought there was an anti-ratification provision in one of these statutes. It says you couldn't ratify.
There is, but plaintiff never invoked that in his complaint and never invoked that in his motion for summary judgment or his opposition.
When was that provision put in there?
It was enacted as part of the FVRA in 1998. But I'm talking about plaintiff's conduct here, whether he raised a claim on that basis at all.
Does it just apply to the Attorney General, or does it apply to all other cabinet members too?
It applies to anyone serving under the FVRA. But at least here, what plaintiff did in his motion for summary judgment and his opposition to the government's motion to dismiss was he didn't contest the validity of the ratification. He didn't say that provision applied here. He didn't say there was any problem with the way the rule had been ratified. Instead, he argued that the voluntary cessation doctrine applied. And that doctrine, in order for it to apply...
By not challenging that, does he concede that the law is something different than what the law is?
No, Your Honor. It's not that he's...
I didn't think that a party could concede principles of law, then concede facts, maybe.
No, it's not that he's conceding principles of law. It's that he never raised a claim that the ratification was invalid. He never advanced this argument in district court in response until a few sentences in his reply brief. And this court has held no obligation.
But if we agree with you and Judge Boyle on standing, we don't have to get to that, or do we?
Well, if you agree with us that the way the complaint is best read is as seeking only relief, and really I think it's frankly the only way to read the complaint, especially in light of the way the case was then litigated, is that it sought relief solely for this narrow few-month period in the past, a declaratory judgment about that period of time. If you agree with us on that, then yes, what Judge Boyle did here is exactly right. There's no ratification challenge at all, and you certainly can't seek declaratory relief related to some past injury. That's doesn't redress that kind of injury. So, when you look at plaintiffs' actual filings here, never raised that kind of challenge. Yes, I'm sorry.
Now, just to make sure that I understand, to go back to, I think, Judge Keenan's question from earlier, your point is didn't raise it below, so we should not now address it. But I take it that you would agree with Judge Keenan's position that if we somehow found it to be adequately raised below, then we could resolve the case by finding under the FVRA that the president was that Barr was entitled to ratify, given that it was a delegable duty.
Of course, yes. If you concluded that it was that this argument was properly raised and not forfeited, even though for all the reasons I've explained it was, then you would have discretion to reach it. Of course, and for all the reasons we've laid out, this was Mr. Barr's ratification was in fact proper. This is not the sort of function or duty in the narrow sense that Section 3348 is referring to. And then even if you got beyond that, of course, then there would be the ratification only matters if you think that everything this court said in Smith was dicta, because of course the ratification is only.
Can you give me an example? So the Attorney General's duties by statute appear to be broadly delegable. Are there other individuals whose duties are not subject to delegation? So in other words, does your reading of this provision, the non-delegation provision, does it read it superfluous, or would it apply? And if so, to whom? In what context would it apply?
There are some statutes that provide that a certain official may not delegate certain duties, and that only.
Can you give me an example if I needed an example?
Sure. I apologize for the length of the citation, but if you wanted to look, for example, at 42 USC 14952 B2, that's an example of a provision that says the Secretary of State can waive certain adoption regulations for international adoptions, but that power, quote, may not be delegated, close quote, right? So there's an example where, and I think if you search that language just in the US Code in general, you can find some examples. Now, it's not a huge swath of duties necessarily, but that's precisely because Congress recognized that it's important to have government continue to function in the event of a vacancy, and that parties who are subject to government action or who are relying on government action need to be able to rely on that action and have government continue to function in those circumstances. And of course, it creates a default rule for Congress going forward. If there are circumstances where Congress wants to mark out certain duties as non-delegable, then in those circumstances, it can do so. It knows exactly what language it needs to use to accomplish that purpose and trigger that consequence under the FVRA. So, the fact that most duties, of course, are delegable is a reflection of Congress's intent. And if you look at the legislative history on the FVRA, it's very clear that Congress was concerned with ensuring that government not be paralyzed in the event of a vacancy.
They didn't want it to be paralyzed, but they also had put that anti-ratification in there because there were some of them that didn't want the president running everything through acting heads of departments, getting around the statutory succession requirements. And I read that this thing is even called the Byrd Rule, and I know enough about the Senator Byrd that was being talked about that he thought that these department heads should go through Senate approval processes.
Well,
I have an idea that's what that was about.
Right. Well, 2 points about that. So one is that for reasons I'm happy to get into in more detail, the text of the actual anti-ratification provision pretty clearly requires this result as compared to plaintiff's reading. But also, Your Honor, the FVRA in general sets all manner of different restrictions and requirements on acting officials and how long they can serve and under what conditions. And I think that package in general is meant to set the ground rules for when the president can have acting officials serve in different capacities. And I don't think I think it's a mistake to focus too narrowly on one particular part of that package, especially where the legislative history specifically about that provision is very clear that it's talking about non-delegable duties, right? It's talking about, for the most part, duties that only that officer can perform. And of course, that's not true here. Not only is the general duties here delegable under the general vesting and delegation statute, but there are two specific delegations that were in effect at the time this rule was promulgated. The ATF director or the deputy attorney general could have promulgated this rule on the day it came out. So to say that the only person who could perform this duty was the attorney general is just simply not correct. There were at least, at the very moment, two other people who could have done it, even independent of the general.
You say the ATF director and the deputy attorney general?
Yes, Your Honor. So and that's why that statutory language is so important. Plaintiff's theory is essentially that whenever there's a delegation, whenever there's a vacancy, those delegations essentially would become meaningless, that they would basically be revoked in the event that a vacancy arises. But that can't be, it's not a sensible reading of the statute, and it's certainly not what Congress intended, as you can tell from the entire discussion of avoiding paralysis in government.
Can I?
These bump stocks had the effect that they turn semi-automatic weapons into automatic weapons. Isn't that correct?
Yes, they convert weapons into machine guns. That's correct.
Yeah. Why wouldn't somebody making a bump stock and distributing it, then they're helping to make a machine gun, correct?
That's correct, Your Honor. Yes.
So why wouldn't that be aiding and abetting a crime since machine guns are illegal?
Certainly, yes. Possession of
you've got criminal statutes on the books to that effect since the 1930s. Why would you need a regulation?
Well, Your Honor, just to give you some background on the litigation over the bump stock rule in general, separate from this case, ATF had previously issued guidance about whether bump stocks specifically qualified as machine guns. That concluded that they were not, and then revisited that conclusion.
Well, they're not a machine gun, but they turned another weapon into a machine gun.
Right. Well, ATF had reached the opposite conclusion.
They combined with a semi-automatic weapon, they make a machine gun.
Yes, yeah, that's correct.
Which has been illegal since 1934, correct?
Well, possession has only been illegal since 1986, but certainly registration has been required since 1934.
Can I go back to the sort of beginning here? And if we had not had an amended complaint and we just were operating under the original complaint, not the second amended complaint, would you agree that adequately challenged the rule as a whole, such that if it was the operative complaint, that it would adequately challenge the ratification? Because it says the final rule is improper and invalid. Would that have adequately, for standing purposes, would that complaint, had it remained in place, allowed Mr. Patrick to have standing at least to challenge the rule in its current form, not just the Whitaker version?
I would have to go back and review that original complaint, but I mean, I think certainly be a lot closer to a realm where that would be true. I mean, not least because you would actually plainly have a prospective challenge to the rule. I still think you would presumably, as a plaintiff, want to amend it.
Because it says to enjoin the final rule, right? If he's seeking to enjoin the final rule and claims to be injured by the final rule, you might well have a mootness argument to be made, but he would have standing on that complaint.
I think that's probably right, Your Honor, but I think that also just underscores why when plaintiff then amended his complaint and stopped, making that sort of request and instead started substituting this theory about the time period between the promulgation and the ratification and needing some kind of relief related to that, really all of this up to and including the argument that he advanced to the district court, which is, well, voluntary cessation applies, which means the government has stopped the relevant conduct that was injuring me, namely the invalidly promulgated rule is now validly promulgated because of the ratification. All the way up to that point, there's no indication that the ratification is being challenged. It's only in their reply that they first start to raise this argument. And this court's been clear, like every other, that district courts don't need to reach out and decide arguments raised for the first time in a reply brief.
Can you address, unless one of my colleagues has a question, the argument that your colleague made that enjoining the FVRA quote unquote policy, they can do that without the president and not involving enjoining the president, relying on the line item veto case. Can you respond to, I understand your argument is that we don't get to that question, but if we got to that question, do you agree that they can seek to declare that the president's sole authority under A3 cannot be exercised?
Your Honor, I want to be careful about answering this and not getting in front of whatever the people above me think about these questions. But I do know as a general matter, we don't think that injunctive relief is available against the president. And to the extent you're seeking injunctive relief against the president, that would not be proper. I think what my colleague was referring to is that not only, so their first count asks for an injunction, And as you point out, there'd be serious problems with trying to issue an injunction that ran to the president or affected the president in carrying out his duties. But they also have these sort of alternative requests for declaratory relief.
Well, if you can't enjoin the president, you can't declare what the president, does as being unconstitutional either, right? Because the Declaratory Judgment Act doesn't expand our jurisdiction; it just supplements the remedy.
Your Honor, I'd want to again just be careful about making broad statements on this particular topic, but I do know that it would be pretty extraordinary to conclude that not only, frankly, that the president is somehow acting unlawfully, it is a policy of the president acting unlawfully, but that's true even where Congress has explicitly by statute conferred that particular authority on the president. Strikes me as pretty extraordinary. If there are no further questions, I would rest on our brief.
Well, you think this ought to be resolved on the standing point if they do affirm Judge Boyle?
I think so, Your Honor. I think you can state that the policy claim.
And if we go past that, you got anything you want to say about that Smith case that I was asking your colleague about?
Well, Your Honor, I think certainly where this court says we hold, I generally take that at face value, and this court in Smith said we hold that Whitaker's appointment complies with the Appointments Clause. And with respect to the FVRA argument, which my colleague was trying to distinguish a bit, it's not all that different from what the court did there. Is not all that different from what plaintiff is asking you to do here with respect to his argument about the ratification, which is even if plaintiff didn't raise that argument, or the criminal defendant in Smith didn't raise that argument in district court, he raised it on appeal, and the court rejected that argument. At a minimum, I think that's all, it's not only correct, as we've explained in our brief, but it's consistent with what every other court, including the Ninth Circuit and numerous district courts, have held when they've looked at the two statutes in conjunction. So, it's sort of 6 of one and half dozen of the other from that standpoint. Thank you, Your Honors.
Thank you, sir. Mr. Wofter?
Thank you, Your Honor. And I'll start with your last question and a response to my colleague on the other side. It doesn't actually, as Judge Friendly cautioned, a judge's power to bind is limited to the issue that is before him. He cannot transmute dictum into a decision by waving a wand and uttering the word hold. And in that case, there's no question that even on appeal, Mr. Smith did not argue that 508 governed the acting attorney general and displaced the FVRA, as we affirmatively argue here. So this court did not resolve the FVRA issue in Smith and is squarely presented here. And I do want to note that, contrary to what my colleague said, we did challenge the ratification throughout our briefing and from the outset, even at the Second Amendment complaint. We initially did it by arguing that it was voluntary.
Can I ask this question? Maybe this will help clarify, at least in my mind. If you did not, in the amended complaint, just accept my hypothetical, that you did not challenge the ratification in your Second Amendment complaint, hypothetically, could you remedy that by making some reference to it in subsequent briefing? So in other words, don't we really just have to look at the Second Amendment complaint? Because if it's raised there, great. If it's not, the fact that you make reference to ratification during the argument or in a reply brief it is not sufficient to save the complaint's allegations, because that's what we have to look at for standing. Is that not fair?
I do think that the antecedent standing question is answered by whether or not we had standing at the outset of the litigation. It's not measured from the point of the Second Amendment complaint. And there's no question.
The Supreme Court in Rockwell tells us that's not true, right? So if you remove allegations that deprive you of jurisdiction in an amended complaint, we look to the amended complaint to establish jurisdiction. And so if you had it in the initial, but you then remove those allegations, then you are then deprived of jurisdiction, right? You're the master of your own complaint. You don't get to bring a federal claim and then file an amended complaint that gets rid of the federal claim and only asserts state law contract claims and allege that you still have federal question jurisdiction because the original complaint included a federal question that you've now dismissed.
I suppose, Your Honor, that if your question is, if you find that the district court correctly determined that our second amended complaint does not prospectively challenge the rule, do we not have standing to prospectively challenge the rule? Then the answer is yes. But I will caution that the upshot to that is that actually will not just decide that issue forever. It will be right before this court again in the future, possibly in front of a different panel. There's no question that my client and others do have standing to bring a claim that the bump stock rule remains invalid because it could not be ratified in this way under 3348.
And you ask us, is that why you ask us to permit an amendment now while it was on appeal?
We did make that request in our opening brief, and that is one, if this court does not agree with us that we have always challenged this rule as we argue, then in the alternative, yes, we have explicitly made that request in our opening brief on appeal, and we would ask this court on appeal, and we do cite a plethora of authority from this and other circuits that allow amendment on appeal under certain circumstances to avoid the cost of judicial resources it would require.
So you have authority. You have Fourth Circuit authority on that? I didn't remember us ever doing that.
Let me step back and say I would need to go back to the brief. I know I cited DC Circuit authority, and I do believe, in fact, that we cited an opinion by Your Honor, Judge Richardson, about when you accept new arguments on appeal, that would apply in this circumstance.
That's where the claim is made below. You can make a new argument for a claim. What you can't do is make a new claim. You're arguing here, and there is some authority, but that's not the right case, that suggests that in some circumstances, we could allow you to amend. I'm not sure I understand how that would work.
Very briefly, to answer Your Honor's question, and because I see that I'm running out of time, and I do want to address the fact that because we did claim that the ratification was invalid because of voluntary cessation, we argue that we can make the argument on appeal that it was also invalid under 3348. That's the Yee v. Escondido and Citizens United cases. And that aside, it was the government that decided to re-raise its ratification defense in response to our summary judgment motion. So it's perfectly natural that we would respond to that defense in our reply. Replies reply to arguments raised in the response. And finally, on the issue of whether or not 3348 applies only to non-delegable statutes, I think it's quite informative that in all of this litigation that we've had with the government, they have now identified for the first time one non-delegable duty by a cabinet officer, and that's the duty to waive certain adoption regulations by the Secretary of State. It is absurd to suggest that what Congress was attempting to do in enacting 3348 was to just prevent the Secretary of State's certain adoption regulations to be later ratified by a validly serving individual. And in fact, Congress did not use the word non-delegable. That was what the minority wanted the statute to say, and that language was rejected for what is in the statute now. This court should not find that Congress enacted sub silencio language it previously rejected. The Congress made very clear that it was trying to take the FERA out of the Doolin ratification context. And critically, the duty in Doolin itself was entirely delegable. So if the government is correct that 3348 only applies to non-delegable duties, then Congress would not have accomplished what it was trying to explicitly do in putting 3348, the anti-ratification provision, in the statute. I see that I'm out of time, so unless there are further questions.
Thank you very much, Mr. Wifter.
Thank you, Your Honors.
We appreciate the arguments of counsel. We'll take the matter under advisement. Madam Clerk, we can proceed to the next case, I believe.
Second case is 19-2380.
Mr. Romano? Are you there, sir?
You're on mute.
Good to have you with us. You may
Can you hear me, Your Honor?
Hear you loud and clear.
May it please the court. My name is Anand Ramana, and I'm counsel for the appellant FCI Enterprises. The district court committed 3 clear legal errors. Each is an independent basis for reversal of the Warren Act judgment, and each is unprecedented.
Hey, Mr. Romano, before we get there, could you tell us why you didn't oppose an appeal bond?
Yes, Your Honor. The simple answer is we couldn't. As Your Honor knows from the record, FCI Enterprises, as of October 5th, 2018, which was the day the company shut down, had no assets and had no money. After the judgment was entered, we attempted to contact 3 different bondspersons, and all declined because there was insufficient security for the bonds.
Did you ever go back to court to ask for relief from the amount of the bond set?
No, we did not, Your Honor. We had already appealed and actually filed 2 notices of appeal at that point. We did not go back, but we...
The problem with this, excuse me, sir, let me just finish this one thing and then I'll cease sentence. It just appears that you're thumbing in the nose at the court. They set an appeal bond, you had a judgment entered against you, and for perhaps a good reason, you couldn't get a bond, but you never went back to the district court. The purpose of the appeal bond is to secure the judgment, and you didn't do it, and you lost in the district court. So why should we hear your case now?
Yes, Your Honor. Absolutely, we were not thumbing our nose at the court. The purpose of the appeal bond is actually not to secure the judgment. The purpose of the appeal bond is to secure costs of appeal. So part of the issue... Well,
tell me what the bond said. I thought it was 300 and some thousand to reflect the amount of the judgment. Was not?
No, that is correct, but that is an incorrect way to calculate what an appeal bond is. Under federal rule of appellate...
300 and some thousand represented then.
I'm sorry, Your Honor?
If the 300 and some $1,000 was not related to the judgment, what was it related to?
It was the amount of the judgment. Federal rule of appellate procedure 7, however, doesn't go towards securing the amount of the judgment. It goes to securing the cost for appeal. It is intended to secure here the plaintiff's victory so that if they are successful on appeal, they have the costs of defending their judgment on appeal paid for already. But that's not what the court did in this case. What the district court did in this case was require posting a bond of over $300,000. That is, in the first instance, the plaintiffs nor the district court even discussed how much anticipated costs on appeal there would be. That would have been the appropriate amount, attorney's fees and costs to brief and submit the papers.
You waived the ability to challenge that. You didn't do anything.
We opposed the motion to dismiss, so I don't think that we've waived any arguments on the motion to dismiss.
Well, you had to post a bond to proceed, didn't you?
We tried to post a bond to proceed, but there was no way for the company to obtain the bond. It's an insolvent company, and so because in the initial briefing papers in our opposition to the motion for bond, we identified how much money the company had, and we did tell the district court we don't have the money to do this, and yet the district court still imposed the appeal bond. If the court dismisses this case because of the failure to post an appeal bond, it would really have a terrible effect on any indigent client, any indigent party to an appeal. What that means is if you can't post a bond to pay for the appeal, then you don't have the right to appeal anymore. It takes away your right to appeal, which is a due process violation, and we've briefed that in our.
There's no showing that these people were, they simply weren't willing to put up enough money to continue their business.
No, Your Honor. And you'll recall that the judgment is only against FCI, the company. And there's an affidavit attached to the opposition to our motion to dismiss where
indigent company can't be indigent. So what is the term that you'd like us to use
insolvent? It had no money. The company has no assets and no money, and it hasn't since it sent that email on October 5th of 2018.
Okay, so if a company is insolvent, then it's excused as a matter of law from posting an appeal bond without going back to the district court?
I don't think that the court needs to create a bright line rule. There is a 4-factor test that we've outlined in our opposition. Is there a good faith? Is there a good faith reason why bond wasn't posted? And here, yes, we couldn't get one. We approached 3 different companies to try to obtain a bond. None would do it because of insufficient assets. Are there merits to the appeal? That's another one. And what that does is essentially deprive our client of a valid appeal if it simply doesn't have any money to post on the bond. The bond itself, and I would like to reiterate, the bond itself, the order for the bond itself is invalid on its face. It had nothing to do with cost of appeal or projected cost of appeal. It only dealt with...
Counsel, let me ask a slightly different question. So I understand your argument. This is not a valid Rule 7 appeal bond. And I'll accept that there's not a whole lot of value in asking the district court to reconsider something that you already lost on. But do you not have an avenue of appealing the appeal bond? So in other words, appealing the very order that imposed the appeal bond? I understand that going back and asking a district court to reconsider a ruling that you already lost may not be required. But are you supposed to bring it to our attention as a part of this appeal, as opposed to awaiting the motion to dismiss?
Well, my understanding, I think I appreciate the question. My understanding is that we only have the right to appeal a judgment. Earlier today, there was an argument on that. This is a post-judgment ruling that could be brought to this court and has been brought to this court by the plaintiffs through a motion, and that was where we decided to oppose it. I don't know if we had the right, I'm not sure if we had the right or that we were even mandated to file a 3rd notice of appeal or an amended notice of appeal, which then said we are appealing the appeal bond by the district court. At that point in time, I think Your Honor acknowledges we had already made our arguments before the district court. This case has a little bit of a history of us making the same arguments before the district court and being rejected. We did make our argument. It was fully briefed in the district court.
Right, but Mr. Romano, why wouldn't you have had the obligation, I guess maybe this is Judge Richardson's question, to come to us and say that the district court denied the motion to stay the judgment, so we shouldn't have to post the amount of the total judgment as might otherwise be required under Rule of Appellate Procedure number 62. Did you ever give this court the opportunity to rule on that?
Well, we did not file a separate notice of appeal for the ruling on the appeal bond. That issue obviously has been raised. I don't, as I mentioned earlier, my reading of this court's jurisdiction is only appeals over final judgments, and this ruling was.
Doesn't Rule 8 of the appellate rules allow that? Appealing the order denying the motion to stay?
I would have to look, Your Honor. I'm not suggesting that we didn't necessarily have the right. We didn't appeal that order at all at this point because we had already filed 2 notices of appeal on the merits. Obviously, at that point, we didn't know that it was going to be challenged in this court.
Okay, well, let me ask you about the merits of your appeal, if I could. I'm really interested in this single site argument. And the reason why I am is that this is something that as a lifelong resident of Northern Virginia, anybody who doesn't work for the government works for a defense contractor almost.
Right.
And so you have, and what the paradigm for these businesses is to operate out of a very small operation with just a few employees. Then employees are scattered at non-company owned sites, governmental sites, like they might be at NASA, they might be at Fort Belvoir, they might be at Fort Joint Base Henderson-Meyer. They're all over the country. What was wrong with the district court's single site analysis? Because this is something we're going to face again and again if we don't end up dealing with it in this case. So how do we? How do you address that problem?
Well, the short answer is the district court didn't really provide much of an analysis on single site of employment, and it's either in its motion for summary judgment opinion or in its Rule 52 memorandum. The legal theory that we're asking this court to adopt is actually very straightforward. There are no legal gymnastics. We're asking this court simply to apply the WARN regulations that define single site of employment found at 20 CFR 639.3 subsection I, or 8 of them. Simply apply those, simply apply the case law that has been uniformly accepted across the country to the facts of this case, and the facts really aren't in dispute. Specifically, the first subsection, those regulations talk about what is, may be, and what is not a single site of employment. The first subsection talks about what is a single, and 3 talks about, well, if they're not right next to each other, they can still be a single site of employment if they share employees or share equipment, if they have the same operational purpose. But subsection 4 talks about what a single site of employment is not, and that is even if the sites are close, if they don't share the same employees or equipment, if they don't have the same operational purpose, then it's not going to be a single site of employment. The biggest issue with the district court's opinion on this is that it doesn't take into account what is as close to a bright line rule on this issue as there is, and that is geographic proximity. All of the regulations talk about geographic proximity and that a single...
But don't they all presume that these are all sites owned by the employer as opposed to the defense contractor paradigm where the employees are situated on government property performing the work?
No, Your Honor. It doesn't presume that at all. If in the regulations, there's not a scintilla of evidence that Congress, well, here in the Department of Labor, even considered property ownership. That's what the employees...
The cases all involve the employer owning, like our property, Mizon, where the other employment site was the Tampa office that they were trying to rely on rather than just their Chantilly office of 2 employees. Is there anything in Warren Act jurisprudence that would suggest, other circuits perhaps, that would suggest in the defense contractor paradigm that the cases involving the single site analysis where the employer does own the other sites are necessarily applicable here?
No, Your Honor, both sides have looked for a very long time to find a government contractor case, and this, as far as I am concerned, and perhaps my colleague has a different view, is a case of first impression insofar as it deals with government contractors. And Your Honor is right to point out that this case, if the plaintiffs prevail, will upend the government contracting industry because it will take these small offices based in suburban Washington, D.C. that assign their employees to permanently live and work out of other locations, military installations around the country, and it will upend it so that all of the employees are imputed. Your Honor, I'm not aware of any cases at all that even discuss property ownership, and that's because, from our view, it's not a factor. There are 2 cases, though.
I'm worried that if if we adopt your point of view, then a defense contractor, unless it's a huge one like khaki, could never be covered under the Warren Act, the employees. And you're just saying, well, that's just the way it goes. Congress could have specified.
No, Your Honor. I think in many of those circumstances, they would be. So, for instance, in this case, I see my time is up. Can I finish this question, please? In those instances, say there was a Raytheon location at a Colorado military installation where there were 60 Raytheon employees. Raytheon, let's pretend for the sake of argument that Raytheon has a small office somewhere that has less than 50. If there was a layoff of those 50 or 60 or 70 Raytheon employees at a military installation in Colorado, that would be subject to the Warren Act, because that would be a single site of employment, even though it's not at corporate headquarters. That would be, and that's what the Warren Act's purpose was. It was to protect communities, local economies from massive layoffs and workers, so that they could get back on their feet again. Your Honor, I'm out of time. I'd like to reserve the rest of the time.
You saved time for rebuttal. Let's see what Mr. Weiss says.
Thank you, Your Honor.
Thank you. Mr. Weiss?
Good afternoon. Thank you for the opportunity. My name is Brad Weiss. I represent the appellees. If it pleases the court, I'm going to start addressing the single site issue, and then I'll work back to the bond issue. So let me address this.
So because it's sequential for me, I hate to ask, but can you start with the bond issue? And
yes, sir.
I want to pose the question that I tried to pose to your colleague. Assume, at least for my hypothetical, that I don't find an obligation to seek reconsideration in the district court. What do you point to suggest that they're required to separately appeal or separately file a motion in the Court of Appeals to challenge the district court's decision on the Rule 7 bond itself?
Sure. Judge Richardson, I'm going to do this by memory. I think it's in our brief as well, but as I recollect when we were briefing this, I believe the appellate rules anticipate such an issue. It's either in Rule 7 or Rule 8 that if they're not happy with the issue of a determination of the requirement for posting a bond, and I'll just say parenthetically, they didn't even follow the rules, which requires you to make a good faith effort to discuss the issue. They could appeal it to the court and raise the issue before the court.
Let me ask you a question. Was there a motion to stay the judgment below?
You're asking me a question. I believe there was, as my best recollection and combination. That's my recollection, but the record would stand whatever it says in there. But I think there might have.
The reason I ask is that if I didn't see it, but I confess I may not know the record as well as some of you do. But the Rule 8, which you mentioned, does provide a separate means of seeking relief, is limited to bonds issued to secure a stay of the judgment, right? Which is not a Rule 7. Rule 7 is not such a bond. It's an appellate cost bond. So I'm just trying to figure out why a litigant who disagrees with the order either has to go back to the district court to seek reconsideration, which we don't typically require, or why they have to separately appeal the order in a separate notice of appeal. And I just, like, where's the rule? Where am I looking for to find?
As I recall, it's been a while since I looked at this issue, but there are two parts to it, because there's one where the district court has jurisdiction over that issue, and then there's a period of time where the Court of Appeals has jurisdiction over it. And in this case, once the district court has issued it, and they then want to challenge it within the Court of Appeals, they have the right to do that. But they didn't follow any of the rules whatsoever. It didn't matter because they didn't invoke any of the standards set by any of the courts. They didn't make a good faith proffer. They didn't seek to discuss or lower the bond. They didn't do any of the rules that are mandated as set forth by all the cases, the Ninth Circuit, the Seventh Circuit, in the effort to post the bond. Let me just say this.
Well, but I understand, but that's a different point, right? So it looks like I've been handed by the Magic Fairy that there was a motion for a stay of the judgment pending appeal, and it was denied. And so I'm just having trouble understanding why Rule 8 gets us there. And I understand your argument on the merits, right? But there's a separate question of whether the issue is forfeited and we're sort of, it's a full stop because they failed to pay or otherwise reconsider or challenge the bond. That's what I'm trying to get at.
Yes, sir. And I think the answer is they had the right to challenge it within the Court of Appeals, and they chose not to do that. And that's their forfeiting of it. They didn't post a bond, they didn't seek to reduce the bond, and they didn't seek to challenge it within the Court of Appeals. So therefore, I submit to you, they forfeited it in multiple ways by not posting it, by not seeking to reduce it, by not seeking to discuss it, and then by not challenging it within the Court of Appeals. And that's been symptomatic of what they've done throughout this case, in my opinion. May I continue? Mm-hmm. So let me go back fundamentally to the, I think it's the central question of the single site of employment. And if you look at the Code of Federal Regulations 20 CFR 639 3A4, it defines an employer who may have one or more sites of employment under common ownership or control. And throughout that section of the regulation, when they talk about single site, they talk about managing, controlling, and ownership. And that's the hallmark of what they're referring to when they talk about examples in the regulation of a auto factory owning or controlling the factories. And in this case, the record that we established was replete that there was only one site of employment that FCI controlled, and that was the headquarters in Chantilly, Virginia. That's cited in the record. And we established in the record that they did not have any control whatsoever of any of the locations of the government installations.
Yeah, Mr. Weiss, in order to prevail then, would we have to find that you qualify under subpart 8?
Yes, Your Honor.
The unusual organizational structure?
Yes, Your Honor.
And if so, how is it truly unusual when you ride the DC Beltway and there are just tons of these places? How can we say it's truly unusual?
It's truly unusual in the sense that it doesn't fit under any of the other categories, and the organizational style of this.
But that can't be enough, right? I mean, the fact that it doesn't fit under the first 7 can't mean, because it doesn't otherwise qualify, it must be under 8.
Well, in this case, the unusual style was the operational, the business development, all of the hallmarks of the operations control, the center, were at the Chantilly location. That is different than other examples. So if you looked at Messon, there, the plaintiff tried to fit under category 6. If you look at some of the other cases around the circuits, you look at the breaking up of where is the operational and the control center. Here in this case, this particular case, everything was controlled out of Chantilly, every aspect of it, development, government contracts, review, personnel, everything. And in fact, the employees reported back physically as well as management-wise to the Chantilly location when they were writing contracts, when they were bidding out contracts, when they were reviewing contracts. they went to the Chantilly location. The only
can I ask a question? Is there any limit? So would subsection 8 cover like basically all consulting organizations, whether we're talking about defense contractors or otherwise? I mean, that's sort of true for all and maybe it does. That may not be a problem for you, but it seems like it's not just defense contractors, it's all consultants. So anybody who's doing a consulting where people are assigned out at various places, no matter how long their assignments, that in your mind, that's an unusual situation. And so they fall under 8.
So Judge Horton, I, like my colleague, have searched every circuit, every case. I've gone back to look at the congressional record and the DOL when they drafted this. The one thing they made clear in 1988 was they could not forecast everything in the future. And they put in the Section 8 for what they called the truly unusual organizational situation. And the reason they put that in there was that they didn't want a situation where companies could evade the WARN Act. It's there as a notice provision. That's the purpose of it. And so I've debated in the office, could you have accounting firms or consulting firms that deploy out persons in such a situation? And the answer is, I think, yes, it could be. In this case, under this set of circumstances, without a doubt, FCI fits that model under 8 as the truly unusual organizational situation where everything was controlled in that one location. The only reason the personnel went to government locations is because they were doing top secret work that required them to be in black rooms, black ops rooms, where it was the only location they could actually do it. There was no signage, no areas, no leasing, no anything at any of these government sites that would identify it as FCI or in any way to indicate that they owned or controlled those sites. Those employees only went to those sites because they went into black rooms to see government information for which they could then report back to Chantilly to do their work, write their reports, review the reports, and then from there submit them to the government. And on that basis, I believe that constitutes a single site. What counsel can't tell you is any case where those other sites, there is no control, ownership, lease, management agreement, because when you go back to the regulations, 639-3A4, it refers to common ownership and control, and FCI had no common ownership and no control over any of those sites. The record is replete with citations to the fact that it didn't, none whatsoever. I'd like to go back to one other point, if I may jump back for a second on the bond issue. In this case, the company gave retroactive termination to the employees on October 8th, saying they were fired as of October 5th and didn't pay the employees for 3 weeks, and then billed the government and collected for all of the money that it didn't pay to the employees, the same company that says it couldn't post a bond. And counsel represented to the court that as of September of 2019, the company had paid $635,295,000 in legal fees. That's JA1965. So for a company that is supposedly insolvent, they collected all the money that they didn't pay the employees, and they were able to pay the attorney's fees as of September of 2019. I just make that.
Okay, Mr. Weiss, let's get to the number of employees. I've had trouble with the record. First of all, the district court's picking the February date, the operative date. And second, I am having difficulty finding 100 full-time employees as of the August 5th, 2015 date.
No problem supplying that for you.
To look
in the record.
We have Mr. Dan Muse talking about 150 employees in August 2015. And there's he also said there were 130 employees on October 5th. I'm sorry, I got the wrong date, 2018. But he didn't seem to distinguish between full and part-time, whereas the WARN Act does. So
yes.
How do we make sense of all this involving employees?
So Mr. Muse had to admit upon examination that the Paycom report that he was referring to was a Paycom report that he pulled in March of 2019 and wasn't completely accurate. We read into the record the name of each and every full-time employee. The record identifies that as of October 5 of 2018, there were at least 130 employees. And Dan Muse testified that as of August of 2018, there were 150 employees. That's JA 192, JA 1652. He had testified that—
When in August?
I don't have the exact date because he gave a presentation to banks. It may have been around August 15th of 2018.
So are you saying, what is the operative date here for WARN Act?
It's going back 60 days. I don't—
So you agree the district court used the wrong date? So
his report did. We then had Mr. Michael.
I guess what I'm trying to figure out is if the district court used the wrong date by using the February date, which it appears that it did, we've got to look through the record and find out if the record's—
No, we corrected that. So what we did is there were multiple dates put into the record. So we went through to demonstrate there was consistency in the number of employees as a result of what Mr. Muse did based on full-time employees and addressed part-time employees. So we had Mr. Nowitzki come back up and testify on, I believe it was redirect. He testified that as of March, he had done a spreadsheet on the software because he'd been asked to do it by accounting so we could establish that was done in a regular course of his employment. That was JA 1827 and 1828. He testified that in January, there were 148 employees. That was true in February and March. That's JA 1831.
Right, but does he distinguish between full-time and part? So
yes.
What I'm trying to get at is it seems to me that under the WARN Act, your date that you have to establish the number of full-time employees is August 5th.
I'm going to get to that in 1 second.
Okay.
He testified that there were only three part-time employees during that time period. That's JA 1831. Mr. Nowitzki testified that even in August, FCI employed 142 employees, and that did not fluctuate from month to month prior to or after that month. That's
but the whole point of that is that chart that he's relying on wasn't updated after March of 2018. That's why it's consistent, is because nobody changed the chart after March of 2018, right? So it's just old data. That's not helpful.
He's testifying that he was the one that was responsible for providing that accounting data. And he said the data didn't change after those months. That's what testimony was. You can believe it or not believe it, but I'm just telling you what he testified to. He said that no time during the 6-month period prior to August 2018 did FCI's employee count fall below 100. That's JA 2265.
Was this during the trial that he was testifying?
Yes, sir. Yes,
did the advisory jury help you any on these questions about the number of employees?
My recollection was they didn't have a problem with it, and the judge then—
Well, did they make any findings or recommendations about it? Or advice? Their advisory jury, did they give any advice to the court about it?
Judge King, I don't recall off the top of my head. I know that they did, and then Judge Judge Alston then gave a memorandum opinion, which he then corrected. I think there was a second memorandum opinion in which he went through it and adopted, but not adopting everything the advisory jury provided. He made—
That's like a Rule 52 findings of fact and conclusions
Yes.
of law, correct?
He took—
But he has to do after having a bench
Yes.
trial.
Yes, he
And,
took out—
he's entitled to take the advice of the advisory jury.
Yes, he took out one employee that we had in there, but it was still well over 100 employees for sure. There was no question based on the testimony, because we read every employee's name that was a full-time employee one by one. In fact, I remember Judge Alston got frustrated because I had problems pronouncing some of the names. My partner had to read them in. We read every single name into the record.
Yeah, but as Judge Keenan emphasized, the date of August the 5th seems to be crucial here. 60 days before October the 5th.
And my recollection is that that was clearly in the record, that there were more than 100 employees well before August 5th, and including August 5th of 2018.
Okay, what are your best JA sites for the fact that there were more than 100 full-time employees on August 5th?
I think I just gave you the sites. JA 192, JA 1652, JA 2194 through 2196, and JA 2265.
Thank you.
31 seconds left. The only thing I'll say to you in final closing is that this is a company where the two venture capitalists took out an awful lot of money. That's a separate issue. There was money to pay the employees. They decided they wanted to play chicken with a bank and not pay the employees, then bill the government, collect it, and not pay these employees. You can judge for yourself on the bond issue. Their decision to appeal, not post a bond, it's a continuing course of conduct in this case. I ask you to affirm the judgment of the district court. Thank you.
Thank you, sir.
Your Honors, thank you, Your Honor. Your Honors, Judge Keenan, I'd like to have the opportunity to provide my best JA sites to the employee count, if I may, for August 6th of 2018. It's not August 5th, it's actually August 6th, because it would be 60 days since August has 31 days. And I'll start with the beginning on how you can calculate the precise full-time employee amount from the record, in this case that's undisputed. We start with the PAYCOM report, which is begins at JA 2051. That PAYCOM report identifies every single employee, total employees, as of October 5th, 2018. That PAYCOM report also has the hire date on the, so it's all of the employees that were working as of October 5th, and it also includes their hire date. There were 130 total employees. From that, we subtract the 30 employees that were hired on or after August 6, 2018. Obviously, we don't count them on the snapshot date if they weren't working there on the snapshot date. So we're at 100 total employees. Counsel was right that at trial, he crossed Dan Muse, the CFO, and elicited that there were 15 employees that were hired before February 6th, but left after August 6th. That's important because they were there, they had the tenure to be a full-time employee, but they weren't included on the PAYCOM list. So we add those because they were working there, those 15. There were 39 names, but only 15 fell within that category. So we add to get 115 total employees on August 6th. But then we subtract 24. The JA sites for the Muse Cross, by the way, is JA 1757 to 71. Then we subtract 24 that were hired between February 6th and August 6th, which means that even if they were working 40 hours a week, they weren't tenured enough to be a full-time employee under the Warren regulation. From that, we get a full-time employee count of 91 on August 5th. If there are no questions about that, Judge King, you asked about findings of fact. During the trial, I asked for a special verdict form for that exact purpose so that the advisory jury could tick off facts and assist the district court. The district court rejected my request, and so the verdict form was a general verdict form. The judge came up with his findings of fact on his own, maybe inferred from the judgment. The advisory judgment, the advisory verdict. But the answer to your question.
And in that context, if I return to the general verdict, would the principle that in that situation that the facts found by the jury are taken in light of the prevailing party, most favorable to the prevailing party, would that principle kick in this kind of situation with an advisory jury?
Well, the advisory jury, at least in my view,
that's what happens if you have a civil case or a criminal case and they return a verdict, the general verdict. Then the facts found that necessary to support that verdict are viewed in the light most favorable to the prevailing party, right?
I think that's right, but we know what the facts were that the district court found, and that's really all that matters legally in terms of challenging the Rule 52 memorandum. And also recall that there was a motion for summary judgment briefing where there were several pages of undisputed material facts, none of which that really has been, this case should have been just ended on summary judgment. But I think Your Honor is right that we can take the facts most favorable to the plaintiffs. And in fact, on this appeal, we do. We're not challenging any of the found facts. In fact, we are using the facts that the court found, even though some of them are not legally significant. For instance, what Judge Keenan found, made a comment earlier about, well, the full-time count in February is legally irrelevant. But we're taking all the facts as true. So I agree with Your Honor, this appeal doesn't depend on this court finding any different facts that are different than what the district court found. It doesn't, we're not, this isn't a sufficiency of evidence appeal. There was one comment that was made. I see I'm running out of time. I don't know if.
Well, Mr. Romana, if we agree with you that the record does not show 100 full-time employees as of the snapshot date in August, what is your remedy? Is it a remand or a final judgment? And tell me what your position is supporting the alternative that you assert.
The remedy is final judgment. There was a full trial. There was a full summary judgment briefing. This court can resolve this on summary judgment. There was a full trial where we elicited facts, they elicited facts. The reason that remand would be futile is because based on the record that I just went through, it would be clearly erroneous for the judge to find anything other than 91 full-time employees. This is at this point a record review. The evidence is closed. They had their opportunity to present their evidence. They didn't. The court didn't find the correct findings of fact. There is a dearth of evidence on this particular issue. If it was remanded, then it would still be 91 absent opening the trial back up, which I don't think would be appropriate in this. So, Your Honor, we are asking for entry of a final judgment in favor of FCI, not just for the 100 employees, but also because the way the district court has applied the Warren Act in this case is a significant judicial expansion of the way the Warren Act has been interpreted and applied for the last 30 years.
And what should we do to punish you for thumbing your nose at the district court and the Court of Appeals on this bond issue?
Your Honor, we didn't thumb our nose at all. I think the record is clear in our opposition for the motion to dismiss that we tried. We did everything that we could. Your Honor, Judge Richardson, we did file a motion to stay judgment, execution of the judgment. That was denied. And in fact, the plaintiffs have started proceedings in the Fairfax County Circuit Court. We've said, go ahead, because there's no money there.
Mr. Romano, my question is, and I guess it's maybe a little widgety, but my question is, when your motion to stay was denied, you're saying the appeal bond simply became one of costs to the people, right?
Correct.
Okay, but the district court seemed to treat it as one securing the judgment, given the amount that it had entered. So it looked like the district court, I don't want to say made an error, but it looked like the district court misperceived what you had to secure on appeal once the motion for stay was denied, okay? Why wouldn't you have to bring it to the district court's attention or this court's attention? Look, Judge, there was a mistake made here, because once the motion to stay was denied, there was no purpose or no validity to securing the judgment. But effectively, what you did, I'm worried about, is that you let this appeal bond order of the district court sail through as an order securing the judgment. You see what I'm saying? By not objecting to it on appeal. And it almost looks like we have an appeal bond securing the judgment, even though the motion to stay was denied. So how do we...
Yeah, just briefly, the appeal bond, I think Your Honor is right that, and I'll say that the district court did err in concluding that it could use the amount of the judgment as a replacement for costs on appeals. That's a facially invalid Rule 7 appeal bond. So enforcing that somehow seems unjust for my client. In terms of letting it sail through, Judge Richardson, I think, pointed out that Federal Rule of Appellate Procedure 8 applies to supersedious bonds, to secure judgments. If we were to appeal the motion to stay execution of the bond and it was denied, I think under Rule 8 we could have appealed that to this court, but we chose not to. We have limited resources. FCI is not paying me as I put in my opposition. It's the insurance company. So Federal Rule of Appellate Procedure 8 would govern that denial. Federal Rule of Appellate Procedure, and again, this was a very quick review and my 20 minutes off, does not apply to an appeal bond. It's a facially invalid appeal bond, and I'm not aware of any requirement.
Facially invalid, but you're not challenging the denial of the motion to stay. You can just kind of, I don't want to say ignore it, but ignore it.
Well, we're challenging the enforcement of the remedy on a failure to pay for the appeal bond, to post the appeal ban on appeal. They tried to enforce their rights for our inability to post an appeal bond on this appeal. We are opposing that on the grounds that we tried, we don't have any money, and this appeal has merit, and the district court should be reversed.
Anything else, Judge Keenan, Judge Richardson?
No, thanks.
No, thanks.
Thank you, sir.
Thank you very much, Your Honors.
Judge Keenan, Judge Richardson, do you need a break, or you want to go to the next case?
Well, I wouldn't mind standing up for about 5 minutes, if that's okay.
Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Our next case is 19-1546, Stephanie Morris versus Lincoln National Life Insurance Company.
Thank you, Madam Clerk. Mr. Glass, are you out there somewhere?
I am, yes, sir, I am.
Good to have you with us, sir. And you represent the plaintiff and Ms. Morris?
I do.
We are pleased to hear from you.
Thank you, sir. In this case, which is a insurance case, life insurance case governed under ERISA, Lincoln abused its discretion by failing to even consider 7 very discrete items of evidence that we submitted or pointed out in our post-remand submission and internal appeal of the case. And under ERISA, Lincoln is a fiduciary, and it's bound to act as a neutral, taking in facts and letting the chips fall as they may. And Lincoln's obligation is to thoughtfully consider, at least thoughtfully consider, the evidence that the claimant submits. And in this case, it ignored them completely. Now, remember the framework for the case, because although the record is very large, we have is the district court had found that Lincoln had abused its discretion sort of the first time around to the district court, and it remanded the case to Lincoln to solve one question. Was Stephen Morris totally disabled as that was defined under the Lincoln policies on January 1, 2015? So that's really where this case that we hear today really starts at that point. It's really a new claim. And so as part of that process, we go back to Lincoln and we submit medical records and in the first round, narrative statements, trying to get Lincoln to focus on Stephen Morris's functionality, his ability to work at any job, even on a part-time basis, on January 1, 2015. That's the single operative issue here. And so we point out to Lincoln, hey, Lincoln, look at the records from December of 2014 and early January and into January of 2014. And let's first look at the medical records. What does it say about Stephen Morris's ability to function? December 10, 2014 record, no new symptoms, feels well, except for mild fatigue. He's got a Karnofsky score, and I'll talk about the Karnofsky and the ECOG score in just a bit, but these are objective measures that oncologists use to assess a patient's ability to live life and to function. It's a language that oncologists use so that they can talk with each other. His Karnofsky score in December 10th was 80%, which is really good, can do sedentary work. December 30, like 2 days before the operative date, record generally feels well, unremarkable review of symptoms. Again, Karnofsky performance score 80%, and he's walking freely. 7 days into January, doing well, no new complaints. A different objective measure, the ECOG score is 1, which means he's not able to do strenuous activity, but he's able to do sedentary to light duty activity. A week later, his only issue is he has a nosebleed. That's on the 14th of January, and the 28th, no abnormal symptoms. In February, he travels down to Texas to a cancer center for treatment. All the way up until August, remember he passes away in September of 2015. And even as of August of 2015, he's at the beach, he's taking walks, he's taking putt-putt golf. He's doing putt-putt golf. The second thing that we asked Lincoln to look at is, hey, we went and got narratives from friends and family, acquaintances, and said, tell us in a statement what you observed about Steve Morris's condition in this January 1, this December to January period in 2014 and 15. I'll paraphrase, but basically, healthiest sick guy we ever saw. So we submit that to Lincoln and say, hey, pay attention, because Judge Trenga said, pay attention to January 1. As you know, under ERISA, these companies, speak through their denial letters. So we get a denial of the claim. Lincoln finds that, oh no, Mr. Morris is not able to do any work, even on a part-time basis. And they cite a couple of things. So number one, they do have an oncologist look at the case. The oncologist quotes in his opinion, it makes it into the denial letter, a purported statement by Mr. Morris's oncologist, Dr. Patel Donnelly. That statement, quote, Mr. Morris was unable to work at all due to his ongoing treatment and chronically low counts during this period from October of 2014 to when he died in September. And Lincoln relies on this statement. That statement could, Dr. Hartner, the Lincoln oncologist, he doesn't get Dr. Patel Donnelly to verify it, as we often see in these cases. They'll send a letter, say, hey, is this what you actually said? This is what I heard you say. But that statement could be one of three things. It could be an opinion that he couldn't work at all. It could be an opinion that he couldn't work at his job, which—
Can I ask, what was that opinion submitted for? So Mr. Morris got that opinion from the doctor and submitted it. What did he submit it for?
So now what you're talking about is our reply, our appeal of Lincoln's initial denial. And that—
No, I think what I'm talking about, I don't recall. That's why I was asking.
Yeah.
Mr. Morris submitted his doctor's statement that he was unable to work for short-term disability benefits.
So that's not what happened.
Help me understand why not.
Well, if what you're talking about is the Dr. Patel Donnelly statement that we just quoted, let's make sure you and I are on the same page. We're talking about that.
Mm-hmm.
Yes, sir?
Yes, sir.
Okay. That's a statement Dr. Patel Donnelly allegedly made in a phone call to Lincoln's oncologist, what we call a peer-to-peer call. So Steve Morris did not submit that statement. The statement that Lincoln relies on in their denial letter was a statement that their oncologist purportedly heard on a phone call.
It was their oncologist statement.
It was his quote of
that he said he heard from his oncologist.
Correct, Judge King. And my point on this will be that we went back to Dr. Patel Donnelly, because once Lincoln denied this claim, then we appeal, right? It's an internal appeal back up to Lincoln. We said to Dr. Patel Donnelly, hey, what if, first of all, did anyone talk to you about what not work means? No. What if the definition of disability was, what's in this policy was, do you think Mr. Morris in January 1, could have worked at an occupation even on a part-time basis? She said, yes, he could have. Now, importantly, in our appeal back to Lincoln, we submitted, in addition to that statement from his treating oncologist, a letter from the employer that said, hey, if Mr. Morris had wanted to work from home, we would have had work available for him. Remember, the treatment he was getting for cancer made him highly susceptible to infection. A lot of the—
So she said, is it correct then you're saying that she said she didn't talk to Lincoln's fella?
No, sir. No, Judge King. What she said was, I didn't understand when I made that statement what he meant by unable to work.
What about Dr. Spira's statements? I had your doctors confused. Dr. Spira on the short-term disability benefits, he or she said that he severely limited functional capacity, couldn't be expected to return to work till April, right? That's Mr.
right.
Morris's own statement on behalf of short-term disability. I mean, I don't know whether it's right or wrong, but it seems consistent with what the oncologist you just described later said, and both seem to provide some evidence that the story now is a little different.
So Dr. Spira's statement is in an attending physician statement dated in October. Remember, that's when Mr. Morris was diagnosed, and he was very sick. And Judge, if the operative date that we were talking about here is October 15, then no, there's no coverage in the case, and we lose, all right? But he started treatment, and all of the evidence around January 1 was that he had the capacity to do at least part-time work and he had the educational background to do work. And so this is where it gets important, because in addition to the Patel-Donnelly explanation, we submitted the letter from his employer saying, yes, if he had wanted to do this work from home, telework, we would have had work for him to do. Remember, he didn't need to do it because he had a good long-term disability policy. Just Keenan.
Yeah, thank you, Mr. Glaus. Aren't you going to argue the distinction too between the two policies and their coverage and defining what is long-term disability? I mean, isn't that part of this case too?
It is. It's not essential. All right. I will tell you that, yes. So there's two policies. There's a basic policy and a supplemental policy.
What I'm concerned with is if we disagree with you regarding the record concerning his ability to work, it appears to me that you still have an argument under the policy language of the supplemental policy.
You're right.
Specifically the 180-day requirement. So I think it might be a good idea for you to at least spend some of your time addressing that.
Let me talk about it. So yes, Your Honor, under the supplemental policy, it defined totally disabled as, and you have been unable to work for 180 days. The reason I say that's not essential, and the court doesn't even need to go here, is because my main argument in this case is that we submitted these 7 pieces of evidence that Lincoln never even considered. They never addressed the narratives, the Patel-Donnelly clarification letter, the letter from the employer, the article from the American Cancer Society, and a vocational report. And ERISA requires 2 things. It requires a deliberate...
No, I understand your question. I guess if I could tell you this is a friendly question, okay?
I understand.
On my part. It seems to me that in order to cover the basis, to have us consider the full range of territory here on appeal, that you need to mention at least the 180-day requirement for long-term disability in the supplemental policy, or you haven't covered all your bases. And I kind of want to hear everything, just so we can consider it all as a group.
Under the supplemental policy, in order for Lincoln to prevail, as of January 1, Stephen Morris would have had to have been unable to work for 180 days, because that was the definition of disability under the policy. And he was not diagnosed. He didn't get sick until October. So he had not been unable to work for 180 days. And I think I'm answering your friendly question.
Well, I'm wondering, how did Judge Trenka go off the rails there? I mean, how did you address that in the district court?
I addressed that in the oral argument that we had, and it's in the transcript. And in our brief, we cite to the page. We cite to the page that we address that. So, I mean, how he didn't address that or why he didn't, I don't know. But again, my fundamental point, though, Judge Keenan, is that we never actually reach, in my view, sort of the merits.
No, I understand your point, but that was my point.
Okay, sure.
Thank you.
Can you at least briefly address the issue exhaustion before the administrator? So I understand, I believe, the argument at the district court, and I think you sort of acknowledged below that you could have done a better job of it, but that you did raise it, and we can evaluate that. But talk to me a little bit about issue exhaustion before the administrator, because it seemed pretty clear that this issue never came up before the administrator. Were you required to do that?
I may or may not have been. So I will agree with you. That issue, that specific legal argument never came up. My bigger ERISA principle point is that they didn't address anything that we sent in our appeal. And when you look at the report of the
let me just back you up 1 second. Let me just ask it a slightly different way.
All right.
Do you agree that there is no issue exhaustion before an ERISA plan administrator? The answer is yes.
Yes. Thank you very much. The point I would like to leave the court with, as I sit down this first time, is JA 115 is the report of the nurse that provides the basis for Lincoln's final denial. It's really clear from that she never even got our appeal. She lists our prior appeals pre-remand. She doesn't mention any of the 7 discrete bodies of evidence that we provided, and she doesn't discuss any. Then, of course, it doesn't make it into the denial letter. So if the court upholds Lincoln's procedure in this case, it's unreasonable reasoning process, in my view. Insurance companies are going to be able to say, look, you send it, we don't even have to discuss it. I'll sit down unless the court has any questions at this point.
Thank you. You saved some time for rebuttal.
Yes, sir. Thank you.
Mr. Decker?
Thank you, Your Honor. Bern Decker for the defendant, Lincoln National. I'm glad Mr. Glass mentioned fiduciary duties, because it's very important to keep the perspective in mind here about Lincoln's duty to adjudicate these claims and strictly enforce the policy terms. And in this case, in this particular case, to look at this issue as if a finding of total disability on January 1st, 2015 meant an award of benefits, because it has to look at it the exact same way if it's deciding a claim for benefits as in this very unique situation with respect to this PIC provision. And that is exactly what Lincoln did. And it's no surprise, and it was not a difficult call. I mean, it was an extremely easy call, and that's why it's no surprise that every person who touched the file, at least 5 people at Lincoln, several people at Reliance Standard, all agreed that for the entire period we're talking about here, which is from when he left work to when Mr. Morris passed away so tragically, he was unable to do any sustained, consistent, reliable work activity for that entire time, including January 1st, 2015. The fact is,
I want you to get your word in on that piece if you like, but to follow Judge Keenan's guidance to your colleague, can you talk a little bit about the supplemental policy and in particular sort of 3 points, and I'll remind you if you don't keep them, but one is issue exhaustion before the administrator. Is there any reason to believe that there is, given the nature of that proceeding and the lack of any plan language suggesting that there is issue exhaustion? Second, what your argument is that it was not raised before the district court, and then third, on the merits, how do you find 180 days to exist between October 15 and January 1st?
Yes, Your Honor, thank you. So the Gale case talks about the exhaustion requirement. Exhaustion is not a plan doctrine; it's a judicial doctrine, and there are very good reasons to require exhaustion because you don't want to become.
To be clear, though, that's administrative exhaustion, not issue exhaustion, right? So this is the Sims case from the Supreme Court in the agency context. But so I totally agree that there's administrative exhaustions required. There's a separate question about issue exhaustion, which is
that's right, Your Honor.
Gale.
That's right, Your Honor. And my contention is that there are good reasons to require, if you've got evidence, if you've got arguments, you bring it forward to the administrator. The Fourth Circuit has never decided it, as far as I know. But the First Circuit has a case called Liston, where they talk about the importance of bringing all your evidence and arguments so that the court does not become a substitute plan administrator. And now you're inserting yourself in a situation that Congress did not intend you to have. I understand the distinction. I think there are very good reasons to require someone to make those arguments. And here, the plaintiff did not. He did not exhaust or preserve the argument in the district court either. There was none of the careful scrutiny that is required. He raised it at oral argument for the first time, and he talked about it for 30 seconds or so. I mean, that is not the kind of preservation.
About what? Excuse me, Mr. Decker, you're saying.
I'm sorry.
What?
The 180 days argument.
Okay, but the contract is in front of the court, though. It's part of the record.
Right, Your Honor, and that's the issue with exhaustion. Again, he never raised the issue below to the administrator, and he didn't preserve it in the district court. He only mentioned it at oral argument. And if you, in the first instance, take upon that issue yourself, you've become a substitute plan administrator, which is contrary to what Congress intended.
So I understand that, but let me just understand on the district court point, right? So he comes to the district court and he says, listen, I was getting ready for argument. I realized this argument that I hadn't thought of before. He's pretty straightforward about it. And Lincoln didn't argue that the issue was waived, and the district court didn't find the issue was waived. And it was presented to the district court. Why would this court find the issue to be irrevocably waived in that situation?
Well, I mean, I think the district court did consider it waived. He hadn't mentioned it in any of the briefs. He mentioned it briefly at oral argument. I think you require
where do I see the district court's decision that the argument was waived?
No, he didn't. I think he considered it waived because he didn't address it in his opinion, Your Honor. And I think that was appropriate. Again, it wasn't preserved enough.
Read lines on that. It's an implied decision by the district court.
Well, again, I think it wasn't preserved enough so that he was focusing on it. I mean, I think that's the point. But if I can move to the merits of it, Your Honor, I mean, the interpretation makes no sense. The total disability requirement under the LWOP provision of the supplemental policy has two requirements. You have to be totally disabled, and you have to be it has to last for 180 days.
Hey, what is the date that we measure the 180 days from?
So we're not talking about the Lincoln policy here.
I'm asking you, Mr. Decker, a very simple question. What is the date from which we measure, for purposes of this appeal, the date from which we measure the 180 days?
My point, Your Honor, is that you don't measure it. It's not part of the inquiry under the PIC. The only issue under the PIC is whether he is totally disabled. To find that totally disabled means totally disabled for 180 days is circular and would not serve the purpose of the PIC at all. What that would mean, Your Honor.
But counsel, wait a second.
The policy. I mean, don't we have to go by the policy? If we find that it wasn't waived in the district court, how do we get beyond that clear policy language? The man didn't know he had acute myeloid leukemia until October, so he clearly didn't meet the definition of total disability in the supplemental policy.
So the supplemental policy, Your Honor, says for this benefit, to get this benefit under the Lincoln policy, which again, we're not talking about. We're talking about the Lincoln supplemental policy through the PIC. In order to get this benefit, if you're on the Lincoln policy, you've got to be totally disabled and it has to last 180 days. You don't merge the two.
Right, but here's the challenge, and this is, Judge Keenan asked, on what date, right? What are we judging it by? And we look at the PIC failure to satisfy work rule, and it says, are not totally disabled on the date the policy takes effect. And I assume you agree the policy took effect on January 1st, right?
That's right, Your Honor. What that means, and it's certainly not an arbitrary interpretation of it, what that means is he totally disabled? Not whether it has lasted for 180 days. That's what it means.
No, but totally disabled is capitalized. It's a defined term.
That's correct, Your Honor.
Term on the previous page, which requires both the sickness piece and the 180-day piece. I mean, it has to include both because it's a defined term.
Your Honor, that is completely certain. What that would be saying is that when we're looking at the PIC, we're going to take anybody on the Lincoln policy. You could be on your deathbed. You could be in a deathbed. We'll take you as long as you haven't been out of work for more than 5 months and 31 days. That is exactly contrary to what the PIC is trying to do. The PIC is trying.
Help me understand that, because I would have thought it's the opposite, right? I thought it made perfect sense. So tell me why that doesn't make sense.
because what the PIC is trying to do, Your Honor, is to make sure no one falls through the cracks, not to have Lincoln taking on a claim that belongs on the other policy. The PIC is designed to determine which policy does this claim belong on. Your Honor, remember.
No, but that's included under point 1, right? So if it's already covered somewhere else, that's one thing, but that's not subpart 4 of the failure to satisfy the active work rule.
Your Honor, that person who's on their deathbed, or Mr. Morris, is entitled to an extension of life insurance benefits from the previous plan. Thus, he's not entitled to take advantage of the PIC. That person that's what the PIC is intended to do, Your Honor. It's intended to not have Lincoln taking on a risk that it can't price for and assess. Somebody who's on their deathbed, after five months and is totally disabled, is entitled to take advantage of that Reliance Standard extension of life benefits plan. And that,
so can you back that up for just a second? Let me make sure I understand your argument.
Yeah.
Your argument is, okay, fine on 4, but we should find that Mr. Morris was entitled to an extension of life insurance benefits under the prior plan.
He clearly was, and that informs both 3 and 4, Your Honor.
How do I know that on 3? Tell me what I'm looking at to figure that argument out. I mean, I just hadn't heard that argument yet. So how would I know that he's entitled to an extension of life insurance under the prior plan?
The prior plan has the exact same extension of life insurance provision as the Lincoln plan. That's a 2659. So if you have to be unable to do any type of work for wage or profit, which you are capable of for your education and whatnot. It's almost the exact same definition. So again, Your Honor, this is not what the PIC was designed to do. The PIC was not designed to allow what happened here is Mr. Morris chose to convert his policy. Had he filed a claim for LWOP benefits with Reliance Standard, they would have had to grant that claim. They would have had to. The PIC.
That's based on the extension of life insurance benefits that you represent as being substantially similar to the one that's found at JA 2659.
Right, and so you have to read the whole PIC together, Your Honor. So what it's trying to do is say, listen, if we're trying to figure out which policy this person comes in under, right? And if they're able to extend under the prior plan, that they're not going to be insured under Lincoln's plan. That doesn't make any sense. And again, to look at what's going on.
The provision doesn't say that, does it?
The intent is clear, Your Honor. It's
what you're doing is argue. Just one sec, Mr. Decker. What I'm concerned with is that your argument is addressing logic rather than policy language, and the two aren't necessarily synonymous.
Let me make the point another way, Your Honor. So it's clear that the PIC is trying to prevent someone from falling through the gaps. Someone who's not at work for a short period of time and dies before they can go back to work. The intent is clear that it's not intended to give someone an opportunity to get something that they would not otherwise get if there was no change in character in carriers. So that's exactly what's going on here.
Can I ask a follow-up question? So if I wasn't going to find what you said I would find on 2659, do you have another suggestion where I could find an extension of life insurance provision? And if you do not have it with my colleagues' agreement, I'd be happy to have you submit it by letter. But I want to see, you say it's subject to it. I just want to see what I'm looking at, and I'll try to find it my own.
Sure, Your Honor. The
659.
The RSL policy is on, it's 2657 to 2662, 2663. That's the RSL policy, and I can pinpoint if I fail to give you the right policy.
No, if it's in one of those pages, I can find it. That's okay.
Yeah. So again, it's not intended to allow someone to get something they could not get if there was no change in carriers. So again, it's instructive to look at what would happen if there was no change in characters. There is no circumstance, Your Honors, that Mr. Morris could ever obtain $1.2 million in life insurance coverage from rights that accrue from the same plan. He couldn't have done that. What happened here is he chose to convert. You cannot convert and keep the group coverage. And Mr. Glass says, no, that's no big deal for people. It's a huge deal for people. The option to convert is extremely expensive. You're turning it into an individual policy. So you've got to pay those premiums. No one is ever going to choose to convert if they can extend the insurance under the prior plan. They won't. That makes no sense. You want to extend the group coverage as long as you possibly can. So if there was no change in coverage, someone in Mr. Morris's position would have filed that LWOP claim with RSL, and RSL would have had to grant it, given what they said about this man's situation on numerous times. Incapable of sustained frequent activity, incapable of sustained work activity on February and March, incapable of any sustained activities. RSL would have had to grant that claim. So what you say, and there are people who can't afford to convert. So what Mr. Glass is asking you to do is to find that someone in Mr. Morris's position who can't afford to convert is not totally disabled under this plan. I mean, that's just not the case. Again, if Lincoln wanted to ignore whether the person was actually totally disabled as of the effective date, it would have said, listen, all you got to do is apply within 5 months and 31 days of leaving work, and we'll take you. That's not what the policy says, and it's not what it's intended to do. So here there was no loss whatsoever, because he was able to convert. He made that choice. He's not entitled to get more than he would have gotten had there been no change in carriers. That's in order to find that, again, you've got to agree with his interpretation of the definition of total disability, which also doesn't make any sense. The notion that you're only going to look at one day when everyone who looked at this file says he's incapable of sustained, reliable, consistent work activity. That's certainly not an arbitrary and capricious or unreasonable way to look at the definition, and that's how everyone who touched the file looked at it, and no one who looked at it didn't. I mean, we talk about the evidence. Judge Trenka got this exactly right in terms of reviewing Lincoln's determination under the arbitrary and capricious standard. As Judge Richardson mentioned, Dr. Spina's APS in October, incapable of even sedentary activity. Dr. Patel Donnelly in December, unable to work at all until June of 2015. Mr. Morris himself on January 5th talks to RSL and says he can't do household activities. He's not going to be able to return to any occupation because there is no remission. Again, as of December 30th, he's in the office with Dr. Patel, and she's telling him, we don't even know if there's a clinical trial that you can participate in. I'm not aware of any case anywhere ever where an insurance company said to a person in that situation, oh yeah, because you've had some good days in between your second failed therapy and your first clinical trial, that you can work, and we're going to say no to your disability claim. And again, had he filed the claim with RSL, that's exactly what they would have done. They would have approved it as any insurance company would have. And Judge Trenka went through the evidence and discussed these issues that Mr. Glass raised in terms of Nurse Sucha, who considered everything. Nurse Sucha had access to the entire file. The referral to Nurse Sucha talks about in detail all of the information that Mr. Glass submitted on the appeal. She obviously reviewed that. She didn't find Dr. Patel Donnelly's retraction of her prior opinion to be of any weight. And Judge Trenga agreed, and I think so would anyone, pursuant to the case law we cited in our brief that talks about doctors who switch their opinions. I mean, that's just not a weighty thing to consider. The procedural argument that there's some requirement to detail every piece of evidence, that's just not the case. The Department of Labor regulations say what has to be in a denial letter. It has to be susceptible to judicial review. It has to have the reasons for the decision that you made and the policy provisions. The Supreme Court says in Nord, you don't have to explain your disagreements. And if you had that requirement, it would not be good. It would not be good for anybody, because it would incentivize claimants to just lard the file with stuff and then gotcha when there's no exact response. So I think that fails as well. It looks like my time is up, Your Honors. Are there any other questions I can answer?
We appreciate your presentation, Mr. Decker. Mr. Glass, you have some time for rebuttal.
Yes. You need to, yeah.
Yes, sir, Judge Cheney. Thank you very much. So Steve Morris, he was not entitled to the extension of benefits under the Reliance policy. He had converted. I have no idea whether that's expensive or not. It probably is. Mr. Decker's probably right. But the reality is that's what he did. And importantly, when you look at Judge Trenga's—
I'm sorry. Back up that a second. You said two different things. You said he was not entitled to extension, and then you said it was expensive, which are not the same point. Well, tell me so I understand the second point, but I'm less interested in it. Tell me why it is you think he was not entitled to any extension of life insurance under the prior plan.
He had converted the policy, and that policy had ended. And this is exactly why Judge—
Converted which policy?
I'm sorry, the prior policy, the Reliance policy, it was coming to an end December 31. He would no longer be covered. Every employee at OG Systems would offer a chance. You can now buy an individual policy. He bought the policy from Reliance. This is exactly what Judge Trenga, this argument that Mr. Decker just made is what Judge Trenga found to be an abuse of discretion the first time around. When Lincoln sent Ms. Morris on a wild goose chase to go get a letter from Reliance saying he would not have been eligible for this extension of death benefit under the Reliance policy. Judge Trenga said, of course he wasn't. He had converted the policy. The policy had—
So where is that? Can you I just want to look at it. Where's the JA site? That's just the first Judge Trenga order is what you're talking about.
Yes, sir. And it's a memorandum opinion, and my assistant may be able to pull the page site.
I can find it. Thank you.
Okay. Thank you. The second thing is, and I just want to go back and thank you for the questions about issue exhaustion. Remember, I think all of these claimants need lawyers to appeal these ERISA cases with their insurance companies, but the vast majority of them are not lawyers. And so to require a consumer to exhaust legal arguments in his or her appeal back up the ladder with an insurance company, that's just not going to happen. And the reality is most of these cases are done by consumers without lawyers like, Mr. Decker and I. Mr. Decker, points out, and Lincoln has argued throughout this case that Mr. Morris self-declared himself unable to work and unable to do any job. And they just ignore that the 2 days later, and this is at 1520, when he's filling out a form for Reliance Standard, and they ask, what could we do for you? And he says, I may be able to work. Again, this is January 7th. I may be able to work from home, do computer work, with limited hours. Look, I heard the questions. My ask of the court would be, because you've used language in several unpublished opinions, like there must be a meaningful dialogue and the insurance company must, at least fairly address these pro-claimant issues that the claimant brings. My ask would be for a published opinion that makes this very clear, follow the other circuits that don't let companies like Lincoln get away with just ignoring this. My friend, Mr. Decker, says, well, Norsucha reviewed and he says, you know, had all this available to her. The court needs to be able to see the work in order to make an independent determination by the district court or you or this court, right, of whether there was a rational and principled decision-making process. You can't find that work in this claim file and this record at all. So unless there's any other questions, we'd rest on our arguments and on our briefs, and Mr. Decker and I are going to get on Zoom and have a beer with each other.
Thank you, Mr. Glass, very much. This case, the appeal will be submitted, and Madam Clerk will call the next case.
Thank you.
$47, Michael Walker versus Donahoe.
Mr. Bryan, you there?
Yes, Your Honor. Can you hear me?
I hear you loud and clear. Good to have you with us, sir.
Good to be with you. Thank you very much. Should I proceed?
You may proceed. Yes, sir.
May it please the court. Obviously, I'm John Bryan, and I'm honored here to represent Michael Walker in this case from Putnam County, West Virginia. Lawful firearm possession and use in West Virginia cannot alone form the basis of reasonable suspicion to perform a stop and investigatory detention of a pedestrian, period. Whether it's 8 minutes long with name calling, such as we had here, or whether it's 18 minutes long with polite and respectful treatment. The district court opined here that the open carry of an AR-15 in West Virginia is a, quote, developing area of the law as courts face the expansion of open carry, end quote. But to the contrary, the legality of open carry in West Virginia is nothing new. It's not on the table at all. It cannot be disputed. United States versus Black was issued by this court 7 years ago, and the right to exercise the open carry of firearms has long been the law of West Virginia. In fact, the right to keep and bear arms for self-defense, hunting, and recreational use in West Virginia is expressly set forth in our West Virginia Constitution in Article 3, Section 22. In this case, Michael Walker was stopped, subjected to a detainment, including a background check, was called vulgar, obscene, and offensive names, all without having committed or even being suspected of committing criminal activity at all. He was just walking. The fact that he had a legal to possess rifle safely and non-threateningly strapped over his shoulder without more cannot be reasonable suspicion to support an investigatory detention.
How do you factor in the age issue? Because the defendant seems to be relying on that as one of its components of its argument.
As with a couple of other arguments made by the defendant in this case, the allegation that my client, Michael Walker, could have been or might have been underage really appeared nowhere in the objective facts in the record. So West Virginia Code Section 6178 prohibits minors under the age of 18 from carrying firearms. Now, the district court wrote in its opinion that although Walker was 24 at the time of the stop, his youthful appearance and the fact that he was walking rather than driving provided a basis for a reasonable officer to suspect that he was a minor. And my response to that is, Your Honor, that the video, and we have a video in this case, the video clearly shows that Michael Walker doesn't have a youthful appearance. In fact, he's...
It depends on how old you are, doesn't it?
It may,
add on, you know, and you have a middle-aged police officer, you know, to somebody in their 20s, this guy clearly wasn't a teenager, but maybe to somebody in his 40s or 50s, he could have been.
This is no doubt an interesting defense that they came up with after the fact, but it must fail, and here's why. There's a couple reasons. One is, even if the court is going to go with a quote, youthful appearance, Well, then the court is venturing into the territory of looking at a video and weighing the facts and performing the job of the jury. If we're going to decide if this is going to hinge on whether Mr. Walker had a youthful appearance, then we have a genuine issue of material fact, and summary judgment should not have been granted in favor of the defendant. We win on that issue in the procedure which we find ourselves in now. Now, secondly, I don't think that it's even a jury issue, because when you look at the defendant, Officer or Deputy Donahoe's testimony, this was discussed during his deposition. He was asked, did you observe Mr. Walker committing any crimes or anything illegal at the time of the stop? His answer was, at the time, I didn't know who he was other than just walking down the road. No, I don't know whether he can possess a gun or anything like that at that point. And so I asked
him. He has to have reasonable suspicion, right?
Yes, Your Honor. And
that's the standard?
I'm sorry, Your Honor.
The officers get a lot of deference in these situations, Mr. Bryan.
Yes, Your Honor.
Do you not know that?
I would argue they get too much deference, but this is
I know,
not.
But they give a lot of it under the law. They get a lot of deference. In gray areas, we give them we defer to them.
Well, I guess we need to define deference, because we're really now getting to the danger that we're facing if this is allowed to stand. And that is, yes, officers.
This thing was just up the road from the schoolhouse, wasn't it?
Your Honor, it was approximately a mile away from a school, and it only came up after the fact. There was no mention at the time of a school having anything to do with this stop. And I can explain. But
that's an objective fact. The location is the location.
That's true, Your Honor. The objective facts, as demonstrated by the defendant's own testimony, shows that the location has nothing to do with the school. In fact, if we're going to put a radius around any school, with the amount of schools that we have in this country, so we would have basically a no Fourth Amendment zone, a radius of decreased Fourth Amendment rights around every school. And
why doesn't it make a difference, though, that the Parkland shooting had just occurred, and here you have a young person walking, young male, and those are the people who tend to shoot up schools, young men, walking with an AR-15 down a public highway? Why isn't that a factor?
That's a good question, Judge Keenan, and here is the answer to that. And I would disagree with the fact that there was any objective fact in the record pertaining to anybody's suspicion that any school, that Michael Walker posed a threat to any school. And I'll explain why. Other than if we look at Google Earth and measure the distance that he was walking, eventually he would get to that school. But there was no basis in the record. A school was not mentioned by any party on the video, which captured the entire incident between the parties. But setting that aside, if he's going to claim, which he did, which I would argue is an irrational fear or a speculation rather than any particular fact about my client, but if he's going to claim that he was a potential copycat of the Parkland shooter, we can look at and see whether there's any similarities. Okay, Nicholas Cruz, the Parkland shooter.
How was this clown of yours dressed?
Well, you can see how he's dressed in the video. I believe he had.
Well, I'm asking you. I don't have the video in front of me. I'm asking you. I want you to tell me how he's dressed.
He was heading coyote hunting. I think he had maybe camouflage pants on or cargo pants on of some sort. He had a sweatshirt on, I believe. He had a backpack that was on his back, and then the rifle was safely strapped over his shoulder and pointed at the ground, I believe. Now, is this an automatic rifle or a semi-automatic rifle? This was an AR-15 style semi-automatic rifle, completely legal.
Did the officer know whether it was automatic or semi-automatic?
he didn't allege that he had any basis for suspecting that it was an automatic rifle.
He wouldn't know, would he, unless he checked it. AR-15, if this was an AR-15, I guess it was. They know now. They're capable. You flip a switch and you make them automatic, right? Or you can put a bump stock on them and make them automatic.
Well, what's happened in this case is
in that case, it would be absolutely illegal. If it was an automatic rifle, it would be illegal, wouldn't it?
No, I mean AR-15s are the most commonly owned.
If it's an automatic, it's a machine gun. Correct.
No, Your Honor. There's no basis for the facts in this case to support any speculation, and that's all that this would be, that this could have been a machine gun. The fact is that the West Virginia legislature authorizes its citizens to possess, which includes openly carrying, AR-15 style rifles, which are perfectly legal under West Virginia law. So there can be no dispute that he was carrying something that day that he was authorized under West Virginia law to carry. And West Virginia law also through our legislature.
After the officer ascertained that, he sent him on his way. What was it, 7 minutes later?
Well, I see what you're getting at, Judge King, but here's the problem with that argument is that defendant Donahoe never established, never even looked at this AR-15 style rifle to examine whether or not it could be a machine gun, which can be lawfully owned in West Virginia so long as the possessor has an NFA stamp that they paid $200 for or whatever.
Counsel, can I ask a scope of your challenge question, if you would? Did you, before the district court, and do you on this appeal challenge the scope or duration of the stop as opposed to the stop itself? I read your argument to be challenging the stop itself, right? The seizure, and not bringing the sort of distinct challenge of, even if the stop itself was appropriate, it extended too long or covered topics that were inappropriate and unlawfully prolonged the stop. Is that fair? I'm asking because I want to be sure we understand the nature of your claim.
That is fair, Judge Richardson, and in fact, I think that this is often conflated, and I believe it was also conflated by the district court, who brought up during the motions hearing at the summary judgment hearing that, well, even if this was an illegal stop, it was only 8 minutes long and it's probably reasonable. And here's the problem with that is, we're contesting the entire stop, the fact that the stop occurred. And we don't need to even look at whether or not it was reasonable or the duration or the scope, because under the binding precedent of this court, United States versus Black from 2013, that stop, just by virtue of the fact that it took place, is by definition under our case law unreasonable.
I appreciate that. I just want to make that clear. Can you also respond just a minute, if you would, on even if you've got a reasonable argument here, why you get over the qualified immunity hurdle? Except that maybe you got a close case on the merits, but doesn't that put us in that gray area that qualified immunity bars going forward here?
Your Honor, I would disagree that there is even a close case for qualified immunity in this case. Now, while it is true that qualified immunity is much more likely to apply or be granted in a Fourth Amendment search and seizure context, this was just so far beyond the pale that there's no argument there. And here's why. United States versus Black, again, a 2013 case, is directly on point to what happened here.
I want you to talk about Black, but do you agree that that's the best case that you've got for the qualified immunity analysis, that to the extent we find it readily distinguishable from this case, that it makes your qualified immunity argument much harder.
Again, Your Honor, I would argue that qualified immunity just can't be granted in this case. You know, the whole, again, if there's a clearly established law out there, if there's clearly established case law of which Defendant Donahoe or any police officer at this time should have been aware of, it's United States versus Black. And that is, I mean, it really, and it goes to the heart of the Fourth Amendment and the Bill of Rights in particular, because if the entire
Black is very different factually from this case, Mr. Bryan, isn't it? I mean, in Black, you had the situation where the officer essentially went after the guy, grabbed his wrist, tried to handcuff him. And that's when he found the metal object under the clothing. You know, Black wasn't, it seems to me that, you know, the only thing the officer had to point to was Black became fidgety, right? Began looking left and right. And the officer concluded he might be trying to flee during the time the officer was trying to process his identification. So it was really a different type of context, wasn't it, than what we have here? You know, we don't have any hands-on in this case. We don't have the officer roughing anybody up. The officer was very rude. There's no doubt about it. And when you look at the tape, your client was very polite the whole time. I mean, you have an imbalance in terms of, social interaction. But in terms of Black, how can we say that Black has to govern when the facts of Black were just so different?
Yes, Your Honor, I'm having some trouble understanding my timer here. It's now counting in the opposite direction. I take that to mean that I'm out of my original time scheduled for this portion. Is it okay if I go ahead and have to? You are out of time, but you have 5 minutes of rebuttal reserved, and you can take as much as that 5 minutes as you want and use it now. Okay. Well, I'll go ahead and answer this question. I think this is an important question, Judge Keenan, and this is very much like United States versus Black. And in fact, I would argue we have even better facts than Black did. Now, Black, the whole point of it is that we can't allow a subjective hunch theory by a police officer, because doing that allows just the sort of evils that the Fourth Amendment and all of our federal case law for the Fourth Amendment is meant to prevent. For instance, high crime neighborhoods and investigatory detentions of African Americans just because they're armed, treating them differently. And that is exactly the sort of thing that we have in this case. There's a neighborhood speculation. So instead of high crime neighborhood like Black, here we have, the sort of area that you don't usually see someone, going hunting, or it's within a mile of a school. So that component is very much like Black. And then you have the other fact that, like West Virginia, North Carolina is legal to open carry. And that fact is same here. And lastly, I would argue just briefly that if you look at the facts in the record, when I questioned Defendant Donahoe, he said that he didn't know Michael Walker from Adam, knew nothing about him, didn't know of any allegation that he had committed any crime, didn't observe him committing any crime, which, by the way, would also apply to the later allegation that he was too young. But this was merely the possession of that firearm. And he said the only reason he stopped them to get his ID is to be able to run his background check and see if he was a convicted felon and therefore could not possess that firearm. But like Judge Gregory wrote in the Black decision, being a felon in the possession of a firearm is not the default status. Where a state permits individuals to open carry firearms, the exercise of that right without more cannot justify an investigatory detention. Permitting such a justification would eviscerate the Fourth Amendment protections for lawfully armed individuals in those states. Thank you. I'll reserve the rest of my time for rebuttal.
Thank you, Mr. Bryan. Mr. Strider?
Good afternoon. May it please the court. I'm Adam Strider, and I represent Officers Donahoe and Pauley in the matter now before the court. The district court made 3 primary holdings, all of which we urge should be upheld. First, that reasonable suspicion existed for the stop on 2 bases. Second, that the scope and duration of the stop were reasonable. And third, failing the first 2, that the pre-existing case law environment at the time of the stop was not such that a reasonable officer would be on notice that a stop under these circumstances would be unlawful. Now,
so before you get started, I asked your colleague this, and since you raised the second point about the scope and duration,
sure,
I didn't read that to be part of the challenge that Mr. Walker was bringing here, and I understand the district court said that, but is there a reason to think that that's actually before us?
No, apart from the fact that it was part of the district court's ruling, and to the extent that it's being challenged here, if it is, then we would contend that the district court was correct there. The first basis,
it was part of the totality of circumstances.
That's correct. The first basis was a reasonable belief that Mr. Walker could have been carrying underage, which is a misdemeanor in West Virginia. And it's not, as Mr. Bryan was trying to frame it, it's not solely based on his appearance, which perception of age based on appearance is subject to reasonable disagreement anyway. But additionally, Mr. Walker was walking in an area rather than driving in an area where foot traffic is uncommon, and younger people are less likely to have a driver's license or own a car. And also, he was wearing a backpack in close proximity to a school. And that's a factor that was considered by the First Circuit in Clark versus Daly, which was a case where
was this a private school?
It is. It's a private school.
And do they wear uniforms?
I don't know.
This defendant was wearing a black sleeveless shirt in the beginning of February, right?
He was wearing a black shirt and camouflage pants.
Right. Sleeveless shirt in West Virginia in the beginning of February. District Court, though, didn't seem to make any particular note of that, did it?
Didn't comment on the lack of sleeves, no. Mm-hmm. But carrying a backpack in proximity to a school is similar to the fact that in Clark versus Daly, the First Circuit found that it was significant that the individual who was stopped on suspicion that he possessed alcohol while underage was present in a college student heavy neighborhood in an area with a large concentration of underage people. Now, we haven't found any case precedent in the Fourth Circuit which would suggest that an officer cannot demand proof of ID when they see someone engaged in an age-controlled activity and have the facts at issue here to form a basis that they might be underage. But extra-jurisdictional persuasive cases.
Well, officer can ask anybody for their ID, can he?
Well, that's correct. But West Virginia,
they might be able to say no, but he's certainly entitled to ask questions.
Well, that's correct. But the case law from West Virginia is not a stop and identify state, but neither is Michigan, neither is Massachusetts. Which are the extra-jurisdictional cases, which give us the persuasive precedent that an officer can detain someone to examine their identification to determine that they're of age. Now logically, there is no other evidence of being underage than your appearance, your environment, your conduct. So if youthful appearance, if presence in an area with a high concentration of underage people doesn't amount to reasonable suspicion to believe someone's underage.
Why wouldn't we think that actually open carrying as opposed to concealed carrying is suggestive that you are of age, right? I mean, the fact that you're sort of like openly carrying a gun, people don't tend to sort of carry their narcotics, so that they're seen. They don't tend to carry contraband so that it's seen. So why doesn't that actually sort of cut the opposite direction?
I don't think it does, because that would set a precedent that if you brazenly break laws, that it suggests that your conduct is legal, and I don't think that's a rule that we want to establish.
Well, it's just a rule of common sense, right? That if you see somebody, at a laundromat with a large bag of white powder, like you don't assume that it's cocaine, right? I mean, I don't think it's a rule. I'm just saying it's a matter of common sense. When we see people carrying guns openly, we tend to think that they're people that are perfectly capable and allowed to do so. No?
I don't think that that's necessarily true. Someone who is just because they're obviously breaking the law doesn't cut against the idea that they might be breaking the law. Now, the second basis for reasonable suspicion was a suspicion of a threat to the community, and this was based on the fact that Mr. Walker was traveling on foot towards a school in a suburban residential neighborhood. Now, Mr. Bryan has made a big deal about the fact that open carry is legal in West Virginia, and it is. AR-15s are legal to possess and facially legal to carry, but reasonable suspicion doesn't require the obvious commission of a crime in the officer's presence. That's probable cause. It's if the totality of the circumstances suggest that there's a reasonable possibility of an imminent crime, and prevention of imminent crimes, as the Supreme Court stated in United States versus Socolow, is a reasonable basis for suspicion for investigatory stop. And the open carry laws don't create an affirmative right. They're just the absence of a prohibition. The West Virginia doesn't have a statute saying that open carry is legal and there's nothing suspicious about carrying a gun anywhere. It's just like any other non-prohibited object. And that, by way of analogy, the Sixth Circuit in a per curiam opinion in the United States versus Ivy found reasonable suspicion where a man was loitering outside of a gas station holding a golf club. To my knowledge, every state is an open carry golf club state. There's nothing unlawful about holding a golf club outside of a gas station, but it's a sufficiently novel appearance of that object, and it's an object that could be used as a weapon. And in that context, it's more, it eliminates a lot of potential innocent conduct to the point that we're left with what's probable is that either something unlawful is going on or something weird is going on. And that's what gives rise to reasonable suspicion. Now, the totality of the facts here are that Mr. Walker is dressed in a manner which is evocative of kind of a militia motif. He's carrying an uncased AR-15 across his back, walking down the side of a road in a suburban residential neighborhood toward a school, and we don't have on the record the exact distance that he was from the school, but it was between a mile, half mile, 8 to 10 minute walk.
I thought Mr. Bryan said a mile, didn't he? You don't.
He said a mile. Estimates have varied: a mile, a half mile, a quarter mile. It was walking.
Yeah, it was the Taze Valley Christian School was the name of it, and this was less than a week from the Parkland shooting in Florida.
It is, and the reason that that's significant is that the Parkland
Judge Chambers recited all that in his opinion.
That's correct, and the reason that that's significant is that the Parkland shooting so saturated national media coverage, the way that it was carried out, the details of it, that not only does this put in the heads of would-be, does this demonstrate to would-be shooters that this kind of activity generates this kind of national notoriety, but it also essentially gives a how-to manual. It shows what kind of a gun kills this many people in this short of a time period. Did
the shooter in Parkland have an AR-15?
He did, Your Honor. As did the shooter in Sandy Hook, as did the shooter in Pulse nightclub, as did the shooter in Las Vegas. it is the hallmark gun of mass shootings, which is why
it was developed as a military weapon by the U.S. Army for the infantry, was it not?
I don't know if that's true or not, but it is evocative.
It was.
It functions in essentially the same way as a military rifle.
If Judge King suggests something about history, you should just agree with him.
Noted, Your Honor. But the fact that it's lawful is not a prohibition on it contributing to reasonable suspicion. Different guns have different uses and they draw different implications in different contexts. If you are to take the situation in the United States versus Black, and it's part of one of the reasons why it's so distinguishable from this case, is that the individual who was open carrying in Black was carrying a handgun in a holster on his hip. Now, the inference there is derived from the fact that carrying a handgun in a holster on your hip is a common practice among people who carry firearms as a matter of course for self-defense. An AR-15 is a big unwieldy weapon. It's not a traditional carry weapon for self-defense. It's also not traditionally used for hunting. And furthermore, this is February, which is not a major hunting season. Mr. Walker wasn't wearing blaze orange, and this area would be unsuitable for hunting anyway. So you have this elimination or improbability of a large portion of potential innocent conduct, and you're left with this is either something concerning unlawful or it's something unusual. And being unusual is not illegal, but when something is either unusual or it's unlawful, that's where investigatory stops are warranted. To touch a little more on Black, first, one of the big reasons Black is—
And Judge Chambers knew all about Black too, didn't he? You all talked about that to him over there.
Judge Chambers ran down the facts of Black and why this is differentiable. And a big reason is that United States versus Black was not a 1983 case. It was an appeal of a motion to suppress. So qualified immunity wasn't an issue in that case. And the second is that Mr. Black, the defendant in United States versus Black, was not openly carrying. Mr. Black was searched because another person in his group was openly carrying, and then a second person in the group the officers knew to have a history of arrests. So the top line ruling in Black was that there's no reasonable suspicion by association. And the other holding of Black is that reasonable suspicion doesn't arise from the presence of a firearm standing alone without more. And the district court acknowledged that and acknowledged that that's the rule, but found that here there is more.
In this case, is all about the more, and that's the whole thing.
All about the more. In Black, the conduct that was observed was that this gentleman was sitting in a car at a gas pump for an indeterminate amount of time, and then drove to an apartment building and approached a group of people. The officers claimed that that was indicative of a drug transaction, and this court found that that was an unwarranted inference to draw. So the fact of the gun was standing alone. Here, the fact of the gun is not standing alone. You have the concern, which I don't know that there needs to be a detailed explanation of why it's concerning that someone appears to be, or at least why it's concerning to anyone who has paid attention to the news over the past decade, why it would be concerning that someone appears to be approaching a school with an AR-15 rifle. But even if this court comes to the conclusion here that the more isn't here, that rhetorically begs the question of what is the more? And that doesn't seem to have been, at least in our review of the case law, established in this circuit in a binding way. Now, the best guidance available to the officers for what constitutes more comes from outside the circuit, from the district court cases in Michigan, in Pennsylvania, and the Sixth Circuit case out of Tennessee that we cited in our brief, where those courts held that reasonable suspicion existed in cases like this, that came to the general conclusion that where a display of firearms is novel and alarming in context, that reasonable suspicion for an investigatory stop arises, even in an open carry state. Tennessee, Michigan, and Pennsylvania are all open carry states. Now, it might be the case, the court might say at the end of this case that heading towards a high school, half, quarter mile away, 10 walking distance, isn't close enough to be alarming, or this conduct doesn't amount to enough to be alarming. But that rhetorically begs the question of what does. In Maciarello versus Sumner, this court said that qualified immunity, to overcome qualified immunity, a right can't simply be established in the abstract. It has to be established in its particularized application, and also that officers are liable for crossing bright lines, not for bad guesses in gray areas. Now, here there does not appear to have been drawn a bright line for the officers to cross, because we don't know what, or in a binding manner, haven't been informed by this court, at least before now, what, in addition to the presence of a firearm, has to be there before reasonable suspicion exists to stop someone openly carrying, and that's the legal environment in which qualified immunity.
You don't want this case decided on qualified immunity, though, do you? You want it decided on the fact there's no constitutional violation.
No, certainly our primary argument is that reasonable suspicion existed for this stop, based both on a reasonable belief that Mr. Walker could have been underage, and based on a reasonable belief that he could have posed a threat to the community generally and the school in particular. But failing that, in the alternative, we'd argue that qualified immunity applies here, and the district court did make that alternative holding, that even if a constitutional violation had occurred, the qualified immunity would still bar the suit. Now, to go back to the question of, and the point that AR-15s are lawful to own, lawful objects in different contexts, you can draw different inferences from lawful objects in different contexts. If you walk into a ski lodge wearing a ski mask, nobody's going to bat an eye. If you walk into a bank wearing a ski mask, it's pretty hard to argue there's not reasonable suspicion there. Or to go with Judge Richardson's analogy earlier, someone with a large bag of white powder at the laundromat probably doesn't have cocaine. Someone who has a large bag of white powder in their car during a traffic stop, well, we're a little less certain. So unless the court has more questions, we believe that the holdings of the district court should stand. The reasonable suspicion existed for the stop. The scope and duration of the stop were reasonable, and they were minimally invasive, and they were balanced against what is properly a grave concern for the safety of the community, and that failing that, qualified immunity should apply.
Thank you, Mr. Strider. We appreciate it. Mr. Bryan, you've saved a couple of minutes.
Yeah, and Mr. Bryan,
right. I'm sorry. Can you hear me now?
Yeah, Mr. Bryan.
I can hear you.
All right. Sorry about that. I guess I was muted somewhere.
Yeah. Mr. Bryan, I'd like to ask you kind of a kickoff question. I think the real important takeaway here from Mr. Strider's presentation is that lawfulness does not mean that lawful behavior can contribute to reasonable suspicion combined with other factors. So why don't we have those other factors in this case? Just focusing on the lawfulness of possessing the gun, Mr. Strider is saying isn't enough. Could you address that?
Yes, that's a good question, Your Honor, and it's a fascinating topic. There is some conflicting case law, even from the Supreme Court, in this. I think the important distinction is that, yes, it's possible for otherwise legal observances to together, looking at the totality of the circumstances, to form reasonable suspicion. However, there still has to be some reasonable suspicion that there's an underlying crime somewhere. And that's the difference in this case, is this is literally falls within the holding of Black, because there is no more. All there is possession of that firearm. And there was nothing about a school that can be seen or heard on that video. That had nothing to do with it. It came out after the fact once lawyers were involved on the defense side. Now,
you agree, counsel, you agree it's an objective inquiry under Wren. We're not looking at a subjective inquiry. So the fact that the officer doesn't mention that on the videotape is neither here nor there, isn't it?
Yes, Your Honor. The reasonable suspicion analysis itself is an objective one, as per the Ashcroft case from the Supreme Court 2011. Now, the argument that this defendant Donahoe had some alleged heightened concern over a potential mass shooting copycat incident due to proximity of the Parkland shooting, that fails to comply with that standard because it's entirely subjective rather than objective. And that makes our case. It's irrelevant to an objective analysis. These subjective hunch type theories have been repeatedly shot down, including by this court. In fact, they were expressly forbidden by the holding of United States versus Black. And this, if the court were to rule in favor of the Pelleas here on this issue, this would completely go against the central tenet of United States versus Black. And in fact, the district court acknowledged that. I mean, the district court said that the district court acknowledged that, yes, there has to be more. Just possession of a firearm in a state that allows its citizens to possess firearms cannot by itself, without more, form reasonable suspicion to perform an investigatory detention. Now, the court wanted a more analysis on what more is, and it expressly wants to include AR-15s in that. And that's a complete red herring in this case. This had nothing to do in the underlying case about attacking AR-15s or declaring them to be, anyone in possession of an AR-15 to be a potential school shooter. I mean, that's just what's outrageous about what happened here. It's because it had nothing to do with it. And in fact, I would request it. I'm sorry, go ahead, Your Honor.
Mr. Bryan, I haven't heard you say anything during your whole presentation about the fact that this all started with a 911 call from a concerned citizen. Can't that be something that the officer is acting in response to and be a legitimate consideration? Along with, his community policing responsibilities. Here, a citizen has made a 911 call based on this guy walking around with a semi-automatic rifle on a public highway.
Yes, Your Honor, that's a good question. The underlying facts of this case, if you look at what I've put in our brief, an excerpt from the deposition transcripts of me questioning defendant Donahoe, he admits that there is no, that he doesn't know who the 911 caller was or what the actual complaint was. He admits that he had no information that Michael Walker had committed any crime. The only information he had, which wasn't information, was his speculation that, well, he could be a felon and therefore a prohibited person under state and federal law. And in fact, he goes on.
You're saying the 911 call really has nothing to do with our analysis here.
No, there's nothing in the record to substantiate a finding of to support reasonable suspicion from the 911 call. It theoretically could if the facts were different, but he said he didn't even know what the 911 caller said. And that's common in open carry calls is it's just somebody that is scared of guns or doesn't know that open carry is legal in West Virginia, and they just call 911. And so he had no information at the time that he stopped him. It was merely
the fact that it's legal in West Virginia doesn't mean people aren't going to be scared when they see somebody walking around with it looking dangerous to them.
Yes, Your Honor, but that's irrelevant to the reasonable suspicion standard. I believe I'm out of time now. I'd like to.
And anonymous tips are used by police officers every day.
Yes, that's.
But anyway,
correct.
go ahead. I've been very liberal. You got more than 5 minutes that you've reserved, and I gave you some extra time too. Give you another 30 seconds to wrap it all up.
Yes, Your Honor, and I'm glad that you brought up the 911 caller and potential tips to police, because we have a wealth of case law out there from the United States Supreme Court on third-party tips to police. So here, even though we have no information on what the tip was, whether it was a tip and who the caller was, we don't even have information. And we can look at Illinois versus Gates from 1983, or Florida versus JL from 2000, or Navarrete versus California from 2014. If you look at these cases, you have to look at the totality of the circumstances to see even if a third-party tip is reliable enough for a police officer to stop somebody. And in fact, Florida versus JL 2000, the Supreme Court held that an officer may not stop and frisk someone based solely on an anonymous tip that describing the person's location and appearance, but contained no details about any illegal conduct in which that person was participating or had participated. So I'll leave you with this, Your Honors. I appreciate the additional time, and one last sentence here. And as Judge Gregory noted in his opinion from United States versus Black, he said, in the words of Dr. Martin Luther King Jr., we're reminded that, quote, we are tied together in a single garment of destiny, caught in an inescapable network of mutuality, that our individual freedom is inextricably bound to the freedom of others. Thus, we must ensure that the Fourth Amendment rights of all individuals are protected. So even if somebody has an irrational fear of firearms, whether it's a 911 caller or whether it's this police officer, we can't allow those individuals to eviscerate the rights of the rest of us. Thank you.
Thank you, Mr. Bryan. Good to have both of you with us. If we were in Richmond, we'd come down and shake hands with you and tell you personally good to have you there, and you did a good job, but maybe next year we'll be there. Thanks so much.
Look forward to it, Your Honor.
Madam Clerk.
Thank you, Your Honor.
Madam Clerk, we'll adjourn court for the day, and the judges will go into conference.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Judges, I'm going to move you now into the virtual